changed. WPC number.
Here is also application for delay.
That 50%. Same day, both the orders.
You just pass the similar order, huh? Two in the interlocutory applications. All right. The next date in the case?
21st August, along with WA number 1071 of
fix on
2020.
that date. Along with
WA number 1071 of 2023. This is
the
1070.
copy of the which you have given to us.
Yes, yes.
The same.
Both the appeals are identical. That is why.
All right.
Item 3.
List this matter on 28th of August 2023.
My lord,
Are you appearing?
my lord is calling item 3, my lord.
Yes. Yes. Item
My
3.
lord is calling item 3.
Yes.
My lord, this is a public interest litigation, my lord. The government land jungle property has been illegally changed into the public, my lord. I have represented to the RDC for information and necessary action. The application is pending before the RDC at Annexure 3, my lord.
We dispose of this petition.
Yes, my lord. Directing the RDC to examine the representation
Right.
and pass necessary orders.
Heard Mr. G. Madani, London Council, appearing for the petitioner. This is in public interest litigation. For direction over the opposite party number 2, Revenue Divisional Commissioner Central Cutoff, for causing an inquiry in order to restoration. For in order inquiry as to whether any government land categorized as jungle land has been occupied by the persons unauthorizedly.
No, released out it.
So whether it was leased out, just a minute. Sorry, to make an inquiry whether the record of rights have been unauthorizedly prepared in favor of some individuals who are in occupation of this said jungle land, description of which is available at Annexure 1 to this petition. Stop. It has been stated by Mr. Madani that a representation has been filed by the petitioner on 15/11/2023 Annexure 3 to this writ petition, but no action has been taken as yet. Mr. D.K. Mohantil, an additional government advocate appearing for the opposite parties, has submitted that the opposite parties number 2 may be directed to make an inquiry and to pass an appropriate order as of deemed fit and proper. Stop. In view of the above, in view of what has emerged from the submission of the Learned Council, we direct the opposite party number 2, the Revenue Divisional Commissioner Central Jan Cuttack, to consider the representation of the petitioner dated 25/11/2023, Annexure 3 to the writ petition, and to take appropriate action in accordance with the law. Stop. If required. Stop. In terms of the above, this petition stands disposed of.
Obliged, my lord.
Item 4. Item 4, may I please?
Yes.
It's a case of my lordship that the for eviction of the opposite party number 5 and 6 over the government land consisting of village number my lordship Adibada PS no Nuaga is the private opposite party has illegally encroached the said government land, and that the land Tahsildar, who is opposite party number 4 my lordship, he has inquired about that, but he has not come to the conclusion and has not evicted the said opposite parties my lordship.
If he doesn't come to the
That-
conclusion, how these persons can be evicted?
In that any physical action has not been made out by the Tahsildar.
That I understand. First, he has
Any
to be
inquiry-
satisfied.
As per
Mr. P.C. Jana.
my
Yes.
lordship, if a notice will be served.
P.C. Das, Land Council, appearing for the petition. This is a public interest litigation seeking evictions of unauthorized occupants of the government land, particularly the opposite party number 5 and 6. Stop. It has been stated by Mr. Das Land Council that petitioner has filed a representation on 14/2/2023 to the Tahsildar Noagaon. But the Tahsildar has not considered the said representation in the perspective of the case. As a result, there had been no action against the encroachers, be that as it may, issue notice returnable on 14th of September 2023. Since Mr. D.K. Mantil, an additional government advocate, appears in web's notice for opposite parties number 1 to 4. No formal notice is called for in respect of those opposite parties. However, the petitioner shall take steps for service of notice on the opposite party number 5 and 6 within 3 days by registered post with
My
80.
lordship.
My lord,
It
in-
is your case that execution encroachment case has started since 2007. Why are you not making that submission?
That submission that he has not taken any action.
So won't you say that encroachment case has been started since 2007?
That has been not sought out, my lordship.
So that we will
Will
look at the
notice he will
plaintiff
appear, my lordship. My lordship.
my lord, in item number 3, free copy of the order. So RDC, I will
Okay,
come.
okay. We copy of the item number 3.
Item 3.
Mr. Jena, why have you stated that there is this eviction procedure?
Eviction procedure, my lordship. No,
Happy if you read your brief and come to the court.
page 8 is
All
for
right. Just a representation, huh? For representation for executing the order dated 9/10/2007 as passed in LE case number 233/2007. But the Tahsildar has not acted upon the said representation in the manner as is required in the circumstances. Change that line. Call it.
item 5, obligement.
Regarding challenge of the GI order 2009 lordships, 17th is the next date. Virus of the GI order
When the other matters are there,
17th.
do you have a copy of this order? Any copy?
Lordship, I'll provide.
All right. So we are passing the similar order. Mr.
Chandrakant.
Chandrakant Naik, Land Council appearing for the petition. He will pass a copy of the order, huh? Follow this order. Right now, you don't have the copy. Okay, you give the case number, connected case number. Next,
Item 6.
Defects to defects.
May I please, Lord's Master? My lord, the sealing proceeding, that the sealing surplus land already vested to government in 2004, my lord.
Hmm.
But the Tahsildar and the other authorities are not quality the record of rights. Therefore, number of sale deeds already adjudicated and the ROR was issued in page number 68 to 108, my lord. All are the government property, my lord. Therefore, I file a PIL to save the government land where the green environment is there, my lord, but more than 100 acres is a kaju forest is there, my lord.
You had filed earlier writ petitions which has been dismissed.
No, my lord, dismissed, that is not dismissed.
WPC 13979 of 2004.
Yes, my lord. In this case, while the order of this vesting has been challenged by two other parties.
So
by the
challenge who won't you state in your date chart?
No, that is not dismissed, my lord. In the order 3-1
In your date
2022.
chart, appendix B, appendix 2, you have said WPC 13979 of 2004 dismissed, was challenged the impugn order for quashing.
That order has challenged the ceiling holder.
What is the
has-
meaning of that averment you have said? Dismissed
no.
was challenged the impugn order for quashing.
No, my responsibility, I am a natural PL, my lord. But the ceiling holder has only to grab his property. He has challenged the order of this vesting, my lord.
So that won't you state in your date chart who has challenged?
Yes, my lord. I am already.
What order, who has challenged? This date charts and synopsis.
The order
are
is
just
there, my lord. I have
practical
already quoted my order, man.
formality. Right, whatever they feel like.
Why your officer is not just executing the order for restoration of land in the favor of the government? What is the interest? And how these officers are being tolerated by the hierarchy?
In fact,
Same.
see, page 19. And there is another writ petition is pending.
13512
Yes,
No,
no,
my lord.
145, yes, 14512
of
2007.
2007.
Yes.
List along with that. No, that has been dismissed for non-prosecution.
There is
that
no
is
more
still
pending.
pending.
He has made a
No,
statement
that
that
is
is dismissed.
You must have filed
So next page you'll.
My lord.
pending.
Next
That
page,
petition
my,
has been dismissed for non-proceeding.
Non-proceeding, my lord.
no, next page, my lord, we can see. As you passed in respect of said, and the said writ petition is still pending.
See, down below. This is the problem of the date chart. Two other entries below you see.
Dismiss,
Whether that writ petition is pending or not.
dismiss, my lord. I ordered that it.
Now you have written that is dismissed by order dated, but somewhere you have stated it is
Before
pending
that.
also.
That
So
is
in
the
the
mistake. That
date
is the
chart, one
mistake.
day it's pending, 2 days later it is dismissed.
No, in the come to the paragraphs, original paragraphs. Where have you stated that was dismissed by an order of this court?
That in date charts, my lord, that the 21/10/2022.
Forget about dates, just come to the original paragraphs. Where have you stated such thing?
Yes, my lord.
What yes, where?
I am showing, my lord. I am showing, my lord.
Date chart is different, writ petition is different. Go back to law school. Okay, then.
My lord, page 5, my lord. Even though petition filed in IA, in earlier writ petition, I have directed to file a intervener in the pending case, my
That's
lord.
not the point.
I filed IA number 5091 of 2020 in intervene the double PC number of 14512 of the 2007, but the intervention application not considered, whereas the main writ petition was dismissed on 21/10/2022, my lord. Therefore, the prayer or grievance of the petitioner about the safe government land and the green environment could not be entertained on merit of interest of justice, my lord.
Para 4.11.
He has given a specific date, the 21st of October 2022, that writ petition was dismissed for
Yes, that is
non-prosecution.
there on the
Chapter
website. also.
4.11. Subsequently, in para 4.11 is still pending. That is the pleading.
No, that is there. That is the very casual drafting.
So, little bit run file.
The
We are
order being
disposing of this thing, directing the officer to to take the steps for execution of the order.
No, in fact, well, I was verifying the pleadings. Well, pleadings are self-contradictory.
Let him file
For
it.
example, my lord, you can see page 8. One way he's saying that the lands have not been recorded in favor of the state government. Other hand, he is saying that the revenue authorities are illegally leasing out those lands.
private leasing out and the solid.
Unless
It
the lands are
it
recorded.
has been recorded in the name of the government, they can lease out.
ভুল হয়েছে তাহলে ছাড়া
No, no, Gana.
না লিজ
If it is government land, the public officials can lease it out.
ইনস্ট্রাকশন আনু তো নোটিস দেলে
Upon instruction এটি দিয়ন্তু, then we will take
না
action.
লিজ আউট ହେଇନି ସେଟା
মନ
ମୁଁ
ইচ্ছা লেখিଛନ୍ତି କେମିତି?
বিস্টেজ ହେଇ ଲମ୍ବା ପିଟିସନ ହେଇଛି ବୋଲି ଟିକେ ରଞ୍ଜ ହେଇଛି
Then also another pleading is there. Page 10 towards bottom. Similarly, the concerned authority taking advantage of OLR Act, UPL and other acts continue to record the government lands in favor of the private
না
individuals.
ইনক্লুডিং অদার ল্যান্ডস আই সারপ্লাস ল্যান্ড নয় আমার মানে মোর মাইন্ড কোশ্চেন ইজ দ্যাট দ্য তহসিলদার ইজ কন্টিনিউইং converting the government lands, my lord. In place of the surplus land, he has not recorded.
We are this giving you an accommodation. Please go through the pleadings. Pleadings are self-contradictory, creating a lot of confusion. If you need any amendment, file the amendment petition. We will consider. This way, drafting cannot entertain because
My
in
lord,
one
my respect submission, my lord. That I have challenging the area of the Tahsil under Rashtriya Nigam, my lord. In some lands are the selling surplus land and including other government lands. The pleading has shared by my friend,
Alright.
senior friend, that's
Mr. Muduli, you take instruction.
Yes, sir.
What is happening about this Wheeler order? As the matter will listed on 10th of August 2023. Meanwhile, Mr. P.K. Muduli, an additional government advocate who has appeared for the
All the state opposite
parties shall
1 to
take
6.
instruction in respect of what is the status of execution of the order dated 5/3/2004 passed in Wheeler, selling case number 47 of 1974. Stop. Whether in terms of the said order and whether in terms of the said order, record of rights have been corrected or not. Mr. Muduli Land Council is further requested to make this court apprised whether out of this land which was declared as the selling surplus, whether the state has settled any person there either by way of allotment or by creating lease. Stop. Mr. B. Raut and counsel has appeared for the petitioner. All right. In this order in the file. You take instruction, next date you also check up whether you need amendment or not.
yes, ma'am.
Because you are filing a public interest litigation, you cannot make these contradictory amendments in the petition. You have to be very careful.
I careful about one.
Item 7.
May I please, Your Lordship? It's a nature of public interest litigation, my lord.
Yes.
But shall I supply copy? I have not served a copy on the government, my lord, and I supply.
Why now?
My lord, nature of litigation.
Mr. Das, why are you serving the copy now?
My lord, I could not serve my lord on the like I have forgotten my lord. Serving code.
What is the use of serving now? I don't
My lord,
understand.
I
Make
don't
your
understand, my lord.
submission.
If your lordship can take it upon others, some other day, my lord, there is no problem. But nature of allegation, my lord, that an government land is encroached. And the inquiry, all the allegation inquiry was made, my lord. Inquiry, they found that some portion of the government land is encroached. Where the SC and one hostel and school is going on for the SC and ST people, my lord, children, my lord. And in spite of that, my lord, he could not be evicted. Thereafter, I brought to the notice of the Annexure 6, my lord, brought to the notice of the Tahsildar as well as the, my lord, government secretary, my lord, and the collector, my lord, but no action has been taken, my lord. This is the simple grievance in this application, my lord. And if your lordship will see page 23, my lord, Annexure 5, my lord,
that they have inquired and found that some portion of land has been encroached, my lord. That is giving the number
Annexure,
80 feet length and width of 3 feet
annexure,
6 inches.
annexure 6.
Annexure 5, my lord. And this has been brought to the notice notice of the district welfare officer Ganjam and additional ADM, my lord, by Tahsildar, my lord, as regards the encroachment. Page 22 and 23, my lord, your lordship can see.
Very small amount of plot that he is
Plot, my lord, because construction is working going on, my lord, because of this creation, disturbance creating, my lord, that the boundary work is not complete, my lord. Already almost all is complete, my lord. Because of this dispute, my lord, this is not complete.
80 feet into the
80 feet into 3 feet,
80 feet,
very small
3.5
piece of
very
land.
240 square
and
feet.
he has also constructed a house. Now, when constructing a house, my lord, we have brought to the notice of the
You are residing where? Next
that
to his,
village, my lord.
next
that
to his
village.
house.
Next, no, not next to house. In that village, my lord. Village of that. OP number 5 is the adjacent landowner, my lord.
Or Mr. S.B. Das and council.
The construction.
OP number 5 has encroached, my lord.
So what is the meaning of adjacent?
Adjacent of that plot which is recorded in the name of the government, my lord.
Yes.
From
When
From
council
eastern side,
appealed
he
to the
can-
petitioner by means of this petition. Petition is sought for a direction from this court. For eviction of the opposite party number 5. From the plot number 5569. Khata number 717/657 of Mauja Gokornapur under Tahsil Digha Pahandi in Ganjam district. Mr. Das has relied on a communication made by the Tahsildar Digha Pahandi to the district welfare officer Ganjam Chhatrapur, from where we gather that the said plot measures only 0.006 acre. Stop. Even the petitioner at one point of place in the writ petition has stated that the opposite party number 5 has been constructing his building adjacent to the said land. Stop. We are not satisfied whether the opposite party number 5 is an encroachment or not. For that reason, we direct. It has been written to whom? This annexure 6.
Answer, sir, 6, my lord, depends on my lord.
It is addressed to whom?
Addressed to Tahsildar, my lord.
Tahsildar Digha Pahandi.
Addressed to the Tahsildar Digha Pahandi, huh? Be disposed of after due inquiry. The opposite parties are directed to ensure that the government land is not encroached by any person for their personal benefit without proper permission from the authorities. In terms of the above stuff, the said representation dated 17/5/2023, annexure 6 to the writ petition shall be acted upon within 15 days from today.
My lord,
15 days?
order to communicate the order, it takes some time, so 3 weeks may kind.
All right, 3 weeks from today.
May I request one thing to your lordship? Lordship may direct the sub-collector to take this issue because Tahsildar has given the letter. So
No,
sub-collector
he has filed the representation before the Tahsildar.
also filed before the collector.
Or I have directed all the opposite parties,
Yes.
including the sub-collector.
Yes.
So it is your hierarchy of your administration. For
Yes.
whom it is reply, you pass the necessary orders.
Yes.
Huh? No, the Tahsildar will conduct the inquiry. You want that the specific, this collector or sub-collector?
Yes, that is what I.
So this representation. to
Either
the
collector or
authority,
sub-collector.
The sub-collector,
Berhampur.
Berhampur, opposite party number 3 is directed to conduct the inquiry.
Yes.
And suggest the appropriate action to the administration. So in terms of the above, this petition stands disposed of. A copy of this order is served on Mr. Mahanti, London Regional Government Advocate, forthwith.
Obliged.
Item 8.
Obliged.
May I please, Lordship? So there is a massive corruption in the tender process of Lordship. Pursuant to the grievance petition, the inquiries were made by the Chief Vigilance Officer, South Co Utility, and the report has been submitted. That is very annexed to running page 28, the conclusion part, Lordship. Annexed to running page 28.
Yes.
The conclusion part in the last portion, Lordship.
Why don't you give this is a typed copy? These are illegible copies you are submitting in the petition. What is the exact page? Tell us.
28, Lordship. 28.
Yes.
Is the conclusion part, Lordship. By limited period directing the state or authority to take appropriate action pursuant to the annexed to within the stipulated time, Lordship.
The report has been submitted to the authority.
Lordship.
Where have you stated so?
Lordship, that has been submitted and also kindly
Where
glance
have you stated so? Which is the
in the
paragraph?
annexed 4, Lordship, running with 30, Lordship.
No, in your writ petition.
Lordship.
Where have you
Lordship,
stated?
yeah, Lordship, annexed to
I will not look into the annexure. Come to your government. There is
Lordship.
a difference between an government and an annexure.
Lordship.
Where have you stated that it has been placed before the appropriate authority?
Lordship, it already reflected to the authority officer South Co Utility, Barampur. The report
I
was
think where
submitted.
is your government?
Lordship.
Have you not read the petition?
Running page 17, Lordship of the brief, Lordship. In point 44. That in the meantime,
All right.
while Lordship.
We are directing the opposite party number 1 to examine the report and take the appropriate action. Right? Because because of this improper assessment, the government has suffered 19 lakhs. Mr. Mudali, just the chief engineer, we are directing to look into the report and take an action. There is no harm in that.
In fact, this is the government
You are
of
Mr.
India.
Mahanti.
Lordship.
Huh?
In fact, page 28, the first conclusion is estimate was not realistic and amount of 19 lakhs is to be returned to the
We are
consumer.
not entering into the merit.
Yes.
Chief Vigilance Officer report is not a Bible.
Yes.
So the government has the authority of even to not accept that report. He finds that it is not based on certain
The
material
project
facts.
was of the government of India. Project was of the government of India.
No, but your officers this executed it. That you have unnecessarily inflated the price. That is the allegation.
Southco is a separate entity.
Who has executed the work?
Southco. Southco.
But he just come to this his prayer. He says the Chief Executive Officer,
That is of the TPSODL. That is. Yes. Tata
this is a
Power,
private organization, it is a company, I think.
yes, company.
How do you come under a writ petition?
It was in the year like it is in the year 2016, Lordship.
It is their company's affairs, why the court will interfere?
But here the South Co utility is there, Lordship. By that time there was a South Co utility.
So at that time it was South Co utility.
Yes.
So it is your
Now it has
organization.
been taken over by
It
the.
is a taken
Tata
over
Power.
before that.
South Core. At that time also, it was a separate entity, not Government of Odisha undertaking.
It's an organization.
Yes, yes.
It was government organization.
Hmm.
The officers were not the government officers.
No.
Even perhaps the vigilance officer report will be placed to them, they will take, but we cannot issue any writ.
That the massive corruption is admitted, Lordship. The fund has been utilized by the government of India. And there is massive corruption. One person is involved in the massive corruption. For that reason, there was an inquiry was made by the South Court Chief Vigilance Officer. It is in the year 2016. But till then, no action has been taken despite the report has been communicated to the authority.
How can you direct those authorities to take action if they think that I will not take any action?
Lordship.
Because the chief vigilance officer's report is not a Bible that everything is right. He has inquired. It has to be accepted by the authorities.
By that time, it was with the South Court utility. It was government undertaking.
Now that's all they
That is
said.
the
That
basis. Merely saying that it's a government utility, it makes no sense without any document.
It was direct to
And-
take instruction. Rather,
Why?
it was
no, that we will not do. You are seeking the direction. I thought it is a government organization, but it's a private organization.
no,
And
by
they-
that time it was a government organization. Now they have it was to Tata Power.
Well, Southco was under the control of the Reliance Industries. From Reliance, now it has gone to the Tata Power.
It was divided in 4 regional lordship. South Sesco, Southco, Nesco. The different 4 regions are functioning in the state of Odisha. It is part of the one functioning agency. And all are government undertaking organizations. Now they have handed over the same to the Tata Power Distribution Limited.
Now, whether that money has been refunded to the central government?
No lordship. That of money till that money has not been
The
refunded.
central government is not unhappy. Why you are coming?
Here lordship, the central government also write the letter to the authority lordship.
Where?
Annex 3 lordship, they have stated. Annex 3.
This is regarding completely different issue,
Yes,
not about
yes.
the payment of money.
Lordship.
This is regarding some repairing
Yes.
work.
Substandard and repairing the same. They have communicated to the executive engineer South Co. B division number 1, Barampur, Ganjam, Odisha.
Mr. Mudulu, you come to the Annex 4.
Yes, I have seen. There
Your
also
additional
we-
secretary is writing to
Yes.
inquiring into these allegations and submit a report to him.
Yes. But there is no response.
Now this vigilance officer report is there.
No, after that, that was 2016 Chief Vigilance Officer report. And this,
It is a 2019 letter.
Yes,
Just
this
see Annex 4.
yes,
Additional secretary of the government is writing to the administrative officer South Co, Behrampur.
authorized officer.
And so now the report has come. We'll direct him to just pursue the matter, nothing else. Heard Mr. S.K. Mohantil and counsel appearing for the petitioner. This is a public interest litigation urging this court for directing the opposite party number 1, Chief Executive Officer, TPSODL, the then authorized officer, South Co Utility, to take appropriate action on the vigilance report, Annexure 2 to the writ petition. Stop. In the said report, the Chief Vigilance Officer has observed, has concluded as under, and has observed as under. This is para 3.6, there is a observation there. You just quote that observation part, huh? No, it's concluded as an, only come to the concluding part at page 16. Stop. Grievance of the petitioner, despite the specific conclusion of the vigilance officer, no further action has been taken by the authority. So from the letter dated 21/12/2019, Annexure 4 to the writ petition, it appears that one additional secretary of the government of Orissa had written a letter to the administrative officer South Co. Come up for further action. Stop. We cannot direct the Chief Executive Officer TPSODL to take any action. But since it appears from the Annexure 4 that the state has been pursuing the inquiry into the allegation of corruption in respect of the same subject matter, we would direct the Department of Energy to examine the report of the Chief Vigilance Officer as available under Annexure 2 to this writ petition and advise or take appropriate action thereof in a measure to weed out the corruption prevalent in the system. Stop. Mr. M.K. Mudali, learned regional government advocate, has submitted that the TP, just write the name. The report of the Chief Vigilant Officer, South Utility, Berhampur, that TPSODL is a company on which the government doesn't have any control. Stop. That is the reason why we have directed the Department of Energy, who had shown interest in inquiry through the communication dated 21/12/2019, Annexure 4 to the petition, for taking appropriate action on the said report of the Chief Vigilance Officer, South Co Utility Berhampur, Annexure 2 to the petition. Stop. Such action. Stop. The Department of Energy shall take a decision within a period of 2 months from today and communicating the outcome to the petitioner. Stop in terms thereof, this petition stands disposed of. A copy of this petition be order be supplied to Mr. P.K. Mudulil and National Government Advocate forthwith. All right, come to the next matter.
Item 9.
May I please, your lordship.
You're
My
there?
lord, this is a PIL matter in respect of the Ravenshaw University matter. Here, my lord, the cause of action is that, my lord, that the inaction of the state government as well as the Ravenshaw University regarding the minimum faculty position, development of new campus, and restoring the democratic right of the student, my lord. So, the
Who are
present
you?
petitioner, my lord,
Who are you?
I'm a public, my lord, and I
You are
have filed.
representing the democratic right of the students.
No, my lord, the present petitioner is a social worker, my lord.
Ah.
And before this filing, sorry, my lord, before filing this PIL, he has filed several PIL before this honorable court.
Good
and
enough.
some of,
But now I am asking him a question.
my,
That when the students are not interested to exercise their democratic right,
my-
how can he come? The students are not the unlettered person.
no, my lord, here, my lord, the present petitioner was the student of the Ravenshaw University, my
Doesn't
lord,
matter.
and
Doesn't matter. We are concerned with the present student community in the university.
my lord, in respect of the campus which is unutilized by the university, my lord,
Huh.
which is situated at the
Who will decide? All
Zonora,
these matters will be decided in a public interest litigation.
my lord, it
Please. Enough is enough.
bec-
You are there?
my lord,
You are there on record?
yes,
Are
yes,
you-
yes, my lord.
Construction of that building is complete.
My lord, construction building is complete, but it is unutilized.
Well,
Till now-
unutilized, I'm understood. Is it complete or not? I don't think
My-
it is complete.
My lord, it is completed, but it is unutilized. Till now, it is unutilized.
Let the university authority decide it. Let us not
So-
poke into this.
So for that reason, my lord, I filed a application before the chief secretary, but that is pending, my lord. Only my
Chief
grievance.
secretary is nobody in
It is
statute.
an autonomous
No, no,
university.
Yes, yes, yes.
No, chief secretary. my
Sorry,
lord, I'm
sorry,
clarifying.
Mr. Come with the better cases. Don't just abuse the process of the public interest litigation. So many marginalized people's rights we cannot take care of. This is a completely some interest behind it.
My lord,
So,
this
all
is-
right.
my lord, this is,
University authorities, there is a council and university authority, they will take care of whether how to utilize their land and properties.
my lord, but they are not taking care of that buildings, and if this is a university, my lord, this is the university, my
understand
lord,
it.
but there is no non-teaching, there is some difficulties in non-teaching and teaching staff, my lord. There is in the,
We'll raise all these issues as are you from outside?
though I am a social worker, my
How
lord,
do you know all these things? What is the source of
my
your
lord,
information?
that I have taken in my PIL, my lord. I have taken, my lord. If your lordship's permitted.
How you can exercise that right also?
No, for that reason, I made an application to the chief secretary. Chief
Ah.
secretary is the authority, my lord.
All
He-
right, you have had your sufficient time. Mr. S.S. Kenaik Land Council.
My lord, can I pray, my lord? My lord, can I pray, my lord? If your lordships, my lord, liberty may be given to
File a fresh petition.
highly press.
That liberty you are going to close.
My lord, initially, if you-
Sorry, tell your client to come with the better cases. We appreciate that his move that he's coming in the public interest litigation.
Right.
And counsel appearing for the petition in the garb of this public interest litigation. The petitioner has asked before this court to direct the university authority, direct the Vice Chancellor, Ravenshaw University. Opposite party number 3 and 4. To start functioning of the university in the new campus. To facilitate world-class study and quote unquote and research. And also to direct the opposite party number 1, the state of Orissa, to monitor all-round development of the Ravenshaw University by forming a committee headed by the Chief Secretary of the state, so that the Ravenshaw University doesn't lose its due dignity. And additionally, it has been asked to direct the university's authorities to conduct the free and fair election of the Students' Union as per the Honorable Supreme Court's guideline. Having a glance, we say that if we pass this direction, that will directly come in conflict with the university's autonomy to decide how to run the university. Stop. If the petitioner is interested in the development of the university, he can meet the university authorities after taking proper appointment and may place his suggestions to the university authorities. We believe and trust the university authorities is aware of their obligation and to utilize their properties in the manner best possible. So in terms of the above direction, we dispose of the writ petition. Observation, we dispose of this writ petition.
Item-
Mr. J.P. Patnaik, an additional government advocate, has appeared for the opposite parties number 1 and 2. Step.
Item 10.
Obliged.
May it please, my lords.
Is Mr. Palit.
My lords. Present application has been filed, my lords. So the larger issue being canvassed in this application is this, my lords, that Supreme Court, my lords, in an effort, in a bid to clean the audience tables, have directed, my lords, come up with various decisions on public interest litigations from time to time. 2001, my lords, 2. They came up with that decision, my lords.
You come to the last decision of 2017.
My lords, that is
That is the last decision of the
my lords.
Supreme
Lily
Court.
Thomas, 2016. So that said, that gave the qualification. Anybody who's disqualified, my lords, automatically he would lose. And by doing so, Supreme Court, my lords, held under 141 that subsection 4 of section 8 is not the saving, that saving clause will not apply, held it to be ultra vires. Thereafter, my lords, in 2013, that judgment was, my lords, passed. In 2014, another PIL was filed before the Honorable Supreme Court, where the prayer was, my lords, Public Interest Foundation and others, Union of India, this writ petition was filed in 2014, taken up for, my lords, disposal in 2016.
What is
Here-
where have you shown the records of the criminal appeal 880?
I'm sorry.
Criminal appeal number 880 shows this. Have you annexed that?
Yes,
appeal?
yes, I've annexed the judgment. I've annexed the
No, no,
judgment.
judgment, I think record. Some orders, what is the status of this case?
My lords, my entire grievance before your lordship is this, that, my lords, once the Supreme Court has directed that within 1 year, the trial should be, my lords, finished against any MPs and MLAs. By logical extension of this corollary, my lords, would be that the appeal also should be capped to around 6 months. That is my prayer before your lordship. In this particular case, my lords, the Cuttack legislative constituency, my lords, in the Cuttack, my lord, the sitting MLA has been convicted of an, my lords, offense under Prevention of Corruption Act, along with others. This housing, there was some housing board scam,
Yes.
something. My lords, the appeal was filed. I've taken this pleading, my lords, your lordship will. On appeal was filed
Or
on
let me take it
110
to other matter because we will request the government advocate to give instruction on the status of this criminal appeal.
Mal,
Just find out, you take up the matter on 10th of this month.
Have you given the criminal appeal number?
Yes,
yes,
880
I
of
have the criminal appeal
2022.
number, my lords.
880.
Order is also annexed.
You just, because we can see in the system, but you can formally just collect copies and file
Yes,
before us.
Mal, I will pass on a copy to my learned senior friend. CRLA.
What is the
88
status of this appeal?
My lords.
Appeal is in the High Court.
Appeal is, my lords, now, my lords, it is in the shelf. It is not being it's not being pursued by the vigilance department. It's lying, my lords. It's gathering dust.
My lord, there is no
Appeal
system
is-
of pursuing a appeal.
Appeal
Your
is,
lordship's court, because my lord
My
are the
lord.
masters of the list.
Truly,
appeal is
but,
gathering dust, my lord.
But sometimes masters are also influenced by the bar.
Number again, Mr. Palit?
CRLA 880 of 2022.
0.
This is page 148 of my brief, my lord, annexure 3.
But this appeal is of 2022, Mr. Palit.
My lords. The mandate, that is exactly the point, my lord. The mandate of the Honorable Supreme Court is that all trials have to be disposed of mandatorily
Within 1 year, that we all know,
My-
2017.
That your lordship, my lords, grateful, my lords. Your lordship knows that. My lords, now as a logical extension, if the intention of the Supreme Court was to clear the audience tables, clear the, my lords, public life of corruption.
Mr. Palit, because you are talking about a very ideal situation, unfortunately, the court functions not in that ideal situation. I'm telling you one example. One trial was completed within 3 years.
My lords.
Then High Court disposed of their appeal within 1.5 years. Then someone went to the Supreme Court.
My
It
lords.
is pending there for 9 years.
Mr. Palit,
My lord.
that
So we do not have any control over the process.
No, your lordship is only my.
No, your grievance we understand. We
Yes.
understand. We must just set a legal framework so that those are very efficiently and quickly disposed of.
My lord, that has been all along, my lord. That has been all along the intention of the Honorable Supreme Court. See
Yes,
the
yes,
direction,
we,
my lord.
we have no quarrel on that
My lord.
issue. On that issue, Mr. Patnaik, you just take care of the status. Huh?
19 October 2022.
My lord,
conviction
Honorable-
stayed by a reasoned order.
My lord, Justice Ratho was asking question, my lord, probably.
Yes, no, I've got the answer myself. Give us the number
Say.
that the conviction has been stayed.
140. Your lordship got the page? It was supposed to be disposed of in the month of February. And still, my lords,
Otherwise, he
Now,
would
what
have-
happened? That is why.
otherwise he would have been
No, it was
removed,
supposed.
disqualified.
No, this. We are not interested about the disqualification because conviction has been
no,
stated.
no, I am not on merits.
No, not on merit. Conviction has been stated by a very long and reasoned order.
My lord,
So we are not on that because you have to, if
I'm
you want to
also not
challenge,
on
go
that.
to some other forum. But what happened in the 22nd
Yes.
February when the matter was listed?
Your lordship will see the para 18 of the direction, page 116. The list the appeal on 22nd February 23rd for hearing. In the meantime, registry is directed to prepare the paper books and serve upon the concerned counsels appearing for the respective parties. The parties are directed to come ready for hearing. This was the mandate of the, while granting the stay of conviction.
Exactly. That is why I'm talking about what happened. The case was on the 22nd February like that.
My lords, not listed. Probably it was listed and vigilance takes time.
No,
Which-
Mr.
No order is there.
Fair. Everything is there in the registry. You can check, and you are saying probably somebody has taken time.
No,
All orders are
I would-
uploaded on the website.
no, I'm sorry, my lords.
That
I withdraw that. I
Check
withdraw.
up and then you say, don't make vague
No,
statements like that.
I withdraw.
Yes. So you just file a status report
Yes,
in a
I'll
proper
find
manner.
out from the registry and
Mr.
I'll just. let-
JP Patnaik, Learned Counsel, who is appearing for the opposite parties. Number 4 only. No, who is here for, can he appear for the Director of Vigilance?
No, he can't, my lord.
But I will take instruction, my lord, on this present
Who is
fact.
appearing, one comment advocate.
I will serve a copy on the
Will
Vigilance
request
Department.
Mr. J.P. Patnaik, Land Government Advocate, to file a short affidavit on the status of the criminal appeal number number 880 of 2022,
880 of 20.
filed by the opposite party number 3. Simultaneously, we also request Mr. S. Palit Lani Senior Counsel to apprise us about the status of this criminal appeal on the next date.
Computer shows.
Let the matter be listed on 10th August 2023.
Can we have it 1 day prior, my lords? 1 day prior.
11th.
No, 9th.
9th is not possible. 11th or any other date you may prefer. 18th of August.
My lords.
18th of August.
No.
18th of August.
Item 11.
The computer shows, my lord,
Ah.
19th was the last date. It was not been listed thereafter.
After February, it was not listed.
That's the after October 20.
Oh, no, this is roster also doesn't cover. Roster says, no, this matter should be taken up by the assignments made to the particular judges. That we have to also look into that. Suppose this is up to the appeals. If the same amendments for hearing of this 2020 appeals has not been made by the Chief Justice. We will also inquiring into the matter.
This case is only
Different category, you understand, but
genre
it has to be differently categorized in the High Court level. That has not been done. This is a vigilance case, we'll get the priority. That has not been done.
We can also, the High Court rules also, we can amend, my lord, for this.
in the wake of the, my lords,
Nobody, even the State
How,
Council
Mr.
also
Patnaik?
not opposing your prayer.
How can it be
Sir,
amended?
Because of that Supreme Court judgment, if
Yes,
the
yes,
lordship
right,
hold
different
that
categories should be
a
open.
political persons should be
series of judgments.
very easy, there.
Series of
So they can be
Sent
acquitted also,
chamber,
not that.
the judgments.
Let them stand vindicated in the court of law.
There is I think Mr. Palit, you also just find out there is a 2023 judgment
My lord,
is there.
my lords.
It is not maybe a judgment, but maybe the order.
Order. My lord,
But
I
Supreme-
passed on the series of order.
No, no, that
Ashwini Upadhyay.
that we know, but we carefully also go through those judgment.
My lord.
Rest
My
assured.
lord, what I was just indicating out of this year, otherwise everybody will file memos before your lordships to list other person's cases. So
As-
for a public
No,
can
no.
also.
Mr. Palit is not concerned with the
I'm
appeal.
not concerned
is
about the
filing
general public.
It
Yeah,
is the only person in the
case.
court
That is
case
what I have
Only
just
somebody
Mr.
who's
Patnaik.
holding office.
Just a
My
minute.
lords.
Mr. Patnaik, somebody is concerned with this case is Miss Patnaik, not even you. This matter is not being taken up and she's not pointing out to the court. They don't, this is February, it was supposed to be listed for hearing. Nobody is pursuing the matter.
Ms. Patnaik?
Yes.
Appeal, my lord.
She's an she normally is an expert.
So the inquiry or
conducting
status
a lot of
report you
hearings.
just assign to her,
Yes.
she will prepare and
Yes,
she
yes,
will
I
file
will.
through you. Yes. 18th.
Item 11.
18th. Great.
My lord, a copy of the brief be supplied to me. I am
Like to appear
On-
because we have not issued
no only
notice.
just to take instruction what is the matter.
Who are you?
Or I am standing counsel for the Election Commission of India, my lord.
All right, but notice has not been issued,
But
so
because
thereafter you
no,
can.
Mr. Since he is the standing counsel,
Not
supply a
note, I'll
copy.
give it course of the day.
All right, please supply copy. You are not reflecting,
My
supply
lord,
copy.
I'll give it
Obligement.
course of the day.
All right.
May I please, item 11, my lord, I
Ah.
have submitted a
Yes.
an instruction along with the CD, my lord. The FIR was lodged on 25th of June. After that,
You
my
are
lord,
appearing for
I
the
am
petitioner.
Mr. Pradhan is supreme favor, kindly taken up next week.
Because there is a request for let us see what is there.
paragraph specifically 3, 4, 5, and 6, my lord. Steps have been taken, publications have been done, letters have been sent to all bordering OICs and PCs, and raids have been conducted in presence of the father also in various places.
All right.
But
What is the age of the child?
16 years.
Respondents. You have not removed the defects. In
My
the
lord.
meanwhile, the appellant shall remove the defects as identified by the registry. It is made absolutely clear that if the defects are not removed by the next date, we may be persuaded to pass an order for non-prosecution.
Item 15,
My lord, in item 15 and 16, I prefer 2 weeks time to remove the defects as the deponent is seriously ill and he's not able to sign.
All right. At the request of Mr.
Lingaraj Sadangi.
Mr. L. Sarangi, learned counsel appearing for the appellant. Let the matter be listed on 31st of August 2023. Meanwhile, the defects as identified by the registry shall be removed. No further accommodation for the same
My-
purpose will be made by this court. Next.
item 18,
Deep knowledge.
You only have to file the certified copy. For that, the deponent doesn't have to come.
My lord, limitation petition is also not there.
Limitation is there.
That he can do it at his place also, but see.
Yes.
item, wait, please, so lordship, we have filed a fresh wakalatnama. It's a consent application. We have taken consent from the previous advocate.
Want some more time?
My lord, we have already filed the wakalatnama on 31st. Our name is not reflected in the cause list, my lord. And the another thing is, my lord, the cause list says the late filing of requisites. That may be accepted.
You are Mr.
My lord, I'm Mr. P. Das.
You are not there.
No, I'm not.
Even
here.
not in the fresh
We-
Vakalatnama, you are not there.
No, my lord. We have already filed on 31st. That is
Alright.
not on the record. The Xerox copy.
No, we are asking that wakalatnama which you have filed, have you signed in it?
Yes,
Okay.
my lord. I have given the copy.
So B thus. P thus. You have Mr. P thus, no?
My lord, my lord.
And counsel appearing to the appellant has submitted that. That the Vakalatnama,
Fresh copy.
fresh Vakalatnama has already been submitted. So it appears from the registry's note that
2 days later.
since the requisites taking service on the respondents was filed belatedly, registry did not issue the notice. Have you served the extra copy to the government counsel?
My lord, if not solved in the meantime, I'll solve it today in the course of the day, my lord. The list shows it has not
For
been solved.
serving the notice on, huh? For serving the notice on, continue that line. On respondents number 3, 4, 5, 6, 7, 8, 7 and 8. Stop. We direct the registry to issue the notice returnable on 14th of September 2023. So we request Mr. Das and counsel supply the extra copies as directed by the court to Mr. D.K. Mohantil, an additional government advocate,
One extra copy, Mr.
My lord.
who is appearing for the opposite parties number 1 and 2. So, Mr. Dash has already handed over a copy. All right, Mr. Dash is requested to supply that copy in the course of the day.
My lord.
All right. Yes,
My lord.
next.
My lord, in
Return
this
to
case, Mr. Khuntia is accepting notice.
Oh,
In
Mr.
this
not
I-
you.
Not me, Mr.
Only
Last-
Mr.
last
M. K.
date he was
Khutia,
there.
instead of
It is
D. K. Mohanty.
Service matter.
The last date also he was there.
Yes.
Already.
Item 19.
My lord, item 19, I have to file steps for issuance of notice. The office note says that it is already filed, but it
There
is
is a
not
delay.
there in the list. Noting says not filed. Only 1 week time, last chance I will file the requisites.
April notice has been issued. When have you filed?
No, it is not filed as it appears from the noting.
3 months have gone.
There is some miscommunication. So
Yeah, there's an interim order.
No interim order, I think. Oh. So we vacate the interim order.
under 1 week time, last chance, 1 week. It is
Yesterday
a civil matter, consultation arising out of a consultation. It's not.
Mr. D. K. Mohanty and counsel appearing for the appellant has stated that owing to inadvertence, the requisite could not be filed in time. So he urges for a short accommodation for filing the requisite for completing the service in terms of the order dated 26/4/2023. Players tense allowed. Appellant is directed to file the requisite for service within 3 days from today. Stop notice is made returnable on 31st of August 2023. Stop. Interim order is passed earlier shall continue till then. If for any reason the requisites are not filed, within 3 days, the interim order as passed on 26/4/2023 shall stand automatically vacated.
Yes.
Item 20.
In item 20 and 21, both
Yes.
the matters are same. I have served copy on the council who are appearing before the honorable single judge.
Today I received the copy, my lord.
Yesterday I have received the copy.
Who is appearing for the respondent number 1
Yes, they have appeared for respondent number 1.
already?
But I have not 2 weeks time to take instruction. Yesterday I
Forget it, just tell of our, let us see whether the service is complete. Registry's note is something different.
That-
It says the steps for service of notice on the R1 has not been taken.
Yes.
No,
Yes,
that is
I'm-
why.
Your lordship,
Have you filed the Vakalatnama?
I have not filed the Vakalatnama. I have no issue.
Today only we received. We are already instructed our client will get Vakalatnama because in the previous writ
Writ petition, you are appearing there.
there I was appearing in the original application. That's why they solved a copy. We took instruction there whether we will received or not. That yes, you received.
Here, Mr. A.K. Mohanty.
My
no?
lord, my son.
Just take down. Mr. A.K. Mohanty, Lord Council has appeared for the respondents number 1 on instruction, and he submits that he will file the Vakalatnama within a week from today.
Within a week.
Within a week from today. As such, the service on the respondent number 1 is complete. Who are the other respondent?
Only one.
Director General of Employment, this is your party?
Government.
The service on the respondent number 2 is not called for.
Lordship, respondent number 2 is up there. Union Government Council is appearing.
Respondent number 2 in this matter, then there is no union of.
Yes,
council.
madam. Director of General Employment and Training, Government of India.
Oh, who is appearing for them?
Normally, PK Padi appears.
DK Pari.
Madam.
Where is Mr. Pari? Just this. It has been just a last order whether his name is reflected. It is also not reflected. the.
I will also
modifica-
serve a copy on him, Mr. Padi.
All right.
Right.
So Mr. M.K. Kuntia, Learned Counsel, is permitted to complete the service by serving a copy on the copy in the office of the Deputy Solicitor General of India on the order 27 of the CPC. Such service shall be completed within
2 days.
3 days from
Yes.
today. 3 days from today. Stop. Next case 22.
In 21, he is appearing that Mr. Gottia is
No
appearing.
instruction yet, my lord. Yesterday night they have served the government has served a copy to me.
You are appearing for 2.
20 in item 21.
21.
Mr. Mahat is appearing in item.
You are appearing for whom?
Respond number 1.
Read petitioners.
Here in 22.
But I have no instruction yet. I will inform my
We pass the order in which court? This
In item 20.
All right.
only 21. Yes.
So you have been newly engaged by the government earlier. Mr. S.N.
Yes,
Patnaik was appearing.
See,
I am the counsel for the lead petitioners.
I am for the appellant here.
Oh, you are for the respondent in the
Yes,
appeal.
yes.
Tell that you are for the appellant.
I am for the appellant.
What is your good name, sir?
Surendra Kumar Garthia, SK Garthia.
Mr. Sachin says the same way, has appeared for Sachin says. Have you filed the Vakalatnama?
Not file. I have no.
We are passing the same way. Within 7 days, you file the Vakalatnama.
Yes, my lord. I will inform my client. Yesterday night I have.
All right. 7 days time is granted. Same order, just copy. All right.
Okay.
So you serve the copy on the.
Yes, ma'am.
So this material will be listed on 23rd of August 2023. Both the matters, huh?
Item
List the matter on 23/8/2023. Item
22.
Yes, he is appearing in 22. There is no representation for the petitioner. Let the matter be listed on 25th of August 2023. Mr. D.K. Mahanti, National Government Advocate, appears for the
23.
all the respondents.
Yes,
Yeah?
madam.
All
Two
the
respondents.
All right. 23.
In
23.
In 23.
Because we will not pass any order, so we are giving a date.
Yes.
28/8/2023. None appears, huh? Mr. Kuntia's name for the.
In item 23, my lord, state is the appellant.
Item 23.
State is the appellant.
Just Mr. M.K. Kuntia and Council. None appears for the. So there, what happened to this? Yes, make your submission then.
There is a limitation, my lord.
How many days delay?
60 days delay, but
67 days delay.
my lord.
Just to take that down in 2651 of 2023, huh? Or Mr. M.K. Kuntial and National Government Advocate, who appears for the applicant. This is an application under Section 5 of the Limitation Act for condonation of delay. According to the service stamp report, the delay is of 67 days in filing the intercourt appeal against the order dated 8/2023. Delivered in WPC number 2072 of 2023 by the learned single judge. Issue notice, such and such.
Right.
Notice is made returnable on 4th of September 2023. Steps for service on the opposite parties shall be taken within 3 days from today by
Yes,
registered
yes.
post with AD. All right.
24.
It may please your lordship, my lord. There is 47 days delay, my lord.
Have you filed the certified copy?
Yes, my lord, I have filed the certificate copy.
All right.
No, my
First
lord,
take down
only
4280/2023.
Dispenses. My lord, I have filed for dispensing. I am filing the petition for dispensing with the filing of
No, you said I asked you whether have you filed
No,
the
no, my
certi-
lord, sorry, my lord, I could not. No, I have not filed, my lord.
Mr. M.K. Mahathir and
Dispensing.
counsel appearing for the applicant is 4280. This is an application for dispensing the filing of the certified copy of the order dated 3/5/2023 delivered in WPC OA number 956 of 2029, which has been challenged in the connected appeal. Mr. Mahathir and counsel has submitted that he has filed a downloaded copy of the
Yes, I have filed the downloaded copy.
said order, but since he could not file the certified copy, could not obtain the certified copy within time, he has filed the appeal. So we dispense with the filing of the certified copy for the time being. We direct the applicant to file the certified copy immediately after he obtains that certified
Yes,
copy, and preferably within 30 days from today.
Within 2 weeks.
30 days, you collect it and file it. Stop. In terms of the above, this application stands allowed and disposed of. Stop. This is 427. It had Mr. Sachin says, huh? There's an application under section 5 of the Limitation Act for condonation of delay. According to the stamp report, there is a delay of 45 days in filing the intercourt appeal against these order dated such and such. Huh? So we issue notice as to why such and such. Returnable of the 4th September 2023. Steps for service of notice. Whether the government is the parties or all the government respondents? No.
Private respondent.
Since
Private
Mr. M.K.
respondent.
Mudoli, learned additional government advocate, appears and webs notice for the opposite parties number 1, 2, and 3. No formal notice in respect of those opposite parties is called for. However, the petitioner shall take steps for service of notice on the opposite party number 4 by registered post with AD within 3 days from today.
Yes, my lord.
All right.
My lord, I have prayed for stay operation of the honor.
What kind of stay?
My lord, I will be removed from service, my lord. Here, one aspect the honorable single judge has not taken into consideration, my lord.
All right,
That the preference, my lord, the direction was given that if that private opposite party has secured more marks than me, I shall be removed from service, my lord. But the preference shall be given to the Baleshwar district candidate. That private party who was challenging the writ petition, he does not belong to the Baleshwar district. His candidature was rejected due to non-filing the residential certificate, my lord.
All right, let the
What is the meaning of preference,
23rd of-
Mr. Mahanti?
Instead of
Preference,
49,
only
make the
Baleshwar
returnable date
district
in
who will
23/8.
secure more marks, he will get appointment.
He'll get
Status
more
quo,
marks.
maintain the
More-
status quo.
Who was the inhabitant of Baleshwar district who was secure more marks among the candidates of Baleshwar district, they will be get appointment, my lord. Therefore, the
This is a
second, the
government
residents,
policy.
In fact, the corrigendum was issued indicating that the candidate who will seek for preference, he has to file the residential certificate.
certificate.
The observation of the
No, but what is the meaning of preference? All
That-
things being
my
the
lord-
same, then preference will be given.
No, my lord.
So if the candidates' marks are less, what preference?
No, my lord, that less, that only that number of appointments have given many TW schools, my lord,
What is the
in
meaning
all
of
the districts,
preference?
my lord. Some of have been challenged in that writ petition or the
Mr.
pending.
Mohanty, the preference has been well defined by the Supreme Court, as my sister was pointing out.
Yes, my lord.
When you are at the same level, then you can get the advantage. Not that in the merit list you are far below.
No,
Only
here, my
because
lord,
you is inhabitant of a district, you will get the
because
preference.
it
That
is
is not the law anymore.
no, my lord, it is as a contractual job, my lord. Therefore, in a paltry amount, my lord, therefore the preference was given to the district,
Okay.
those who are
Okay.
inhabitant, they can serve there, my lord. Others
All
outside
right.
district, they cannot serve, my lord.
In this I number 4279 of 2023. Heard such and such, huh? Issue notice. This is an application for staying the operation of the same judgment, huh? Issue notice returnable on 23rd of August 2023. We have just prepone the date from the 4th September to 23rd of August. Stop. Mr. P.K. Muduli, same way. Now these other parts, steps for the service be taken on other. Meanwhile, the status quo, so in respect of the engagement of the applicant shall be maintained.
25,
Yeah, as per the SR report, the second copy has not filed.
File it.
Second copy,
Please look at your synopsis and date chart. What have you stated?
that's it.
So according to you, the one date is important, other dates are not important.
No, in your synopsis, you have stated the petition is being filed in the interest of the inhabitants Harinasol village under so and so, which is not sustainable in the eye of law. So we have to reject the WPC.
Wrongly,
What does it mean?
wrongly typed.
So correct all these things.
Lordship.
Let the
File a
matter
better synopsis.
Lordship,
the
I'll file.
matter be filed on 29th of August 2023 at the request of Mr.
As well as date chart.
Lordship, I'll file.
S.
Only
Hotal
one
and
date is
counsel
there.
appearing to the petitioner. So you'd request the Mr. Hota to file the list of dates and the synopsis as the list of dates and synopsis as addressed to the present petition is
Self-destructive.
inadequate and erroneous. Inadequate and erroneous.
26,
You are appearing in this matter?
My lord, I am appearing.
Mr. D.K. Mohanty, learned
Maybe.
additional government advocate appears for the opposite parties number 1, 2, and 3 on advance notice. Okay.
26,
All the matters is one matter is in 1230.
Petitioners provided are the resident of Bargad Canal Colony of BJP Nagar in ward number 45 of Bhubaneswar Municipal Corporation. The grievance of the petitioner that seeking for a direction to the PMC as well as to the Water Corporation of Orissa for maintenance and construction of sewerage and drainage work. And in obedience to my lord directions, so far as the water is concerned, Water Corporation of Orissa is concerned, they have almost have taken up the work and 70% work has been completed. And but so far as the drainage is concerned,
You are Mr. Mohanty.
my lord.
Heard Mr. Dayanidhi Mohanty, Land Council, appearing for the petition.
As for BMC, we have filed the counter.
Pending since 2016.
Only one order has been passed, I find. This no order is there. Only one order.
10 orders.
Where?
In that case, 10 orders. are there. Last order was passed on 2/5/2020.
So you have already filed, Mr. Mohanty?
IA reply was supposed to be filed. IA 6240 of 2023. Whether he has filed or not, because.
Mr. Mohanty, who is appearing for this municipal corporation?
Water Corporation.
For BMC,
I am appearing for the Water Corporation, my lord. And in fact, we have complied because we have complied the order of this honorable court, and it has been commissioned since long. But
No,
due
that
to the-
IA, Mr. Bhuiya, that IA 6240 of 2023.
Yes,
You
ma'am.
are undertaken to file a reply within 4 weeks. So
Yes,
you
my
have
lord.
filed a reply
Yes,
stating
what
all
is my,
this.
yes, my lord. What is
All
my
right.
instruction, my lord?
Where is the reply?
That they have complied this order of this honorable
Where
court
is the
since
reply?
long. It has been commissioned. In fact, they have not taken any connection because of their ignorance. Now, after inquiry, and they have now also applied, and we have been under process that they have to connection, and will comply the order of this honorable court, and will file affidavit for compliance in the next date. It has been commissioned, and construction has been made, And it has been commissioned because of ignorance of the petitioner, they have not taken the connection. Because of that is a three different divisions. One division they have constructed.
No, because their main prayer is the construction of drain by extending such and such. That is number one. Construct a sewerage line straight from the plot number such and such. This is the prayer.
This has been, their prayer is for construction of sewerage system as well as the drainage. Sewerage system, it was undertaken by Orissa Sewerage Board, and this work has been shifted to Water Corporation. In fact, because of as per the order of this Honorable Court, Water Corporation has completed the work in the scheduled time. Their compliance, they have also filed their affidavit for compliance.
Where is the affidavit?
So Water Corporation is a separate entity and Sewerage Board is a separate entity.
It is a separate entity, but due to the redistribution of the work of the government, all this water supply, water management, as well as the sewerage system has been shifted to Water Corporation. Now the
Water Corporation is the opposite party.
9.
7 is filed with it. 9 is filed in reply.
They're saying we have complied. We have not
only this water, my lords, as regards of sewerage system,
No,
it
we
has
are
been
finding
completed.
a reply by this Orissa Water Board. But what is the Water Corporation? Yes.
My lords,
You,
as
you are,
regards-
you are the opposite party number 9.
They have prayed for two-fold measures. One
Yes.
is for sewerage system,
Another is for the drainage.
drainage. This sewerage system has been completed. It has been commissioned because they have not taken the connection because of their ignorance. Now, after inquiry, they have applied for, and it has been under process, my lord. I will file an affidavit because for the compliance of this.
When
order
you
of this.
filed the affidavit, last affidavit?
Yes, I will file it because after the compliance of that, they have applied.
Because
for
no, in the last affidavit you stated the incomplete part is 3.5 kilometers. Only you have completed 1 point some kilometer. So you file it?
No, grievance is confined to 5 petitioners. So it has been, connection have been given to them.
No, we are not concerned. Their general demand is the drainage and the sewerage both. It is not particular 5 individuals. 5 individuals are before this court.
Yes, my lord.
That's all. But their grievance is for all. So you have stated in your last affidavit.
Yes, my lord.
Please come to the last affidavit that you have filed on 5th of May 2022. Am I correct? It is the last affidavit. To come to the 9 numbers of petitions have prayed for their sewerage and such.
Yes, ma'am.
You says you have given the connection to all of them.
Yes, ma'am.
Are you sure?
Yes, we have complied. What is my instruction? We have all
All
complied.
right, file the affidavit then.
We'll
And
file
then-
affidavit.
Then you come to the para 2 of that counter affidavit. You says the balance work to the extent of 3.5 kilometer of the gravity network in Lakshmi Nagar area, division number such and such. Till date is able to complete only 1.52 kilometers.
Yes.
So the remaining part is at 2.3 kilometers, and you promise this court that you'll complete by August 2022.
Yes, ma'am.
Thereafter, no affidavit.
We'll file it affidavit.
We'll take up the matter on 11th of August.
Another thing, Mr. Bhuiya, 9 petitioners have approached this court. That doesn't mean that you will provide sewerage facility to only those 9 and their neighbors will be without any facility.
No, it's for all. Don't just
That
leave
area.
under confusion.
All right.
Yes, my lord.
Please
That's
take
right.
care.
We have. Yes, my lord. So I will, that we have complied the order of this court. In next date, I will file affidavit. What is my instruction? We have complied the order. Because of this, I is confined to these 5 petitioners.
No, we are
Mr.
also asking take instructions
TK
regarding
Bhuiya?
neighboring areas also.
Yes, ma'am.
Land Council has appeared for the Water Corporation Limited and made a statement that they have complied the order of this court by providing the facilities as sought by this public interest litigation.
In respect of these petitioners.
But later on, no, he says that he's stopped. But later on, he has clarified that the sewerage system has been provided to the petitioners of the writ petition. Stop. We are constrained to observe that this writ petition is not confined to only to the petitioners who filed the present public interest litigation. In the affidavit, filed by the Water Corporation Limited, opposite party number 9, on 5/2/2022, they had stated that they, out of the extent of 3.5 kilometer of the gravity network in Lakshminagar area, they had completed 1.3 kilometer on the date of, by the date of filing of the said affidavit, and they promised to complete the rest work of 2.3 kilometers by August 2022. But no compliance affidavit has been filed so far in terms of the said statement made in their affidavit dated 5/5/2022. Therefore, we ask the Water Corporation Limited, opposite party number 9, to file an affidavit of compliance by 11th of August 2023, when the matter will be taken up again. Mr. D. Mohanty, learned counsel, has appeared for the petitioners. And Mr. D. K. Mohanty appears for opposite party number 1, 2, 3, 4. None appears for the opposite party number 5, 6, and 7 when the matter is taken up.
My lords, I am appearing for BMC, my lords. We have filed counter.
All right.
They have stated in paragraph 9 that after construction of drain by irrigation department, the rainwater and wastewater will go.
Who?
BMC.
My lords, it's mainly coming under the jurisdiction of the Odisha Water Supply and Sewerage Board. BMC has limited role, my lords.
File an affidavit, Mr. Mohanty.
Already filed.
Appears for the opposite party number is 7. Huh? Already we'll examine on the next date, 11/8, the matter will come again.
My lords.
My lords, as regards of drainage, my lord, it is the discussion of this BMC has to do this. They have
No,
to,
it is the irrigation department.
only
Government
this sewerage system, this has been constructed by this.
No, that's your liabilities are to create the gravity network, nothing else. We'll refer
Throwing
that.
responsibility on each other.
No.
Paragraph 9.
Their promises regarding the gravity network for the sewerage system that we have reflected.
Paragraph 9 of counter affidavit OP 7.
My lords, drainage and sewerage are two different things, my lords.
I know that I have recorded the sewer for gravity network is for the sewerage only. It is not a part of the drainage.
Yes, my lord.
Okay.
So
Call the matter.
all of you have to do your own part.
Item 28.
Yes. The state is the appellant in all cases. I am appearing in one of such cases.
Okay.
State and municipality both have filed applications.
I think we have to just.
Yes, ma'am.
Is that matter that we have already heard?
It can be hard.
Only the case
Small,
of
very
a
small.
transfer.
The
Only
case-
case of transfer of the 3 employees of the municipality
To
who have succeeded in the single bench. The municipality as well as the state has come up in appeal. We are unable to join and one of us has been terminated in the meantime,
Thank you.
for whom my senior is appearing.
The entire case is like this, Lord.
May I submit?
Subject to my.
Let me start first.
No, just, it can be disposed of if you agree.
Yes.
That is my sense, right? I have not also consulted my learned friend. Lord, in 2019,
Yes.
these people they are the employees of a municipality. They were transferred to another municipality by way of deputation, and at that time there was no cadre.
on item
in
No,
2000.
we are something wrong.
Then you
Cadre
then
role
you-
in 2017.
But that has not been
Not
given
been
effect.
implemented.
Yes.
Who is appearing for the appellant? Talcher municipality?
Yes, my friend is municipality.
You are appearing for the municipality.
Let him please.
Why have you challenged the order?
Yes, ma'am. May I draw my
He
lords?
has to submit first.
Yes,
Mr. Panda.
Mr. Panda, you make your submission first. We have challenged this order of
Limited role. Since the order of transfer issued by the government has been under challenge, municipality has a limited role, your lordship. Since the order of transfer issued by the government, that is under challenge and they have succeeded in the writ petition, I supported the stand taken by the government.
So that is the reason.
May,
But the government has also filed the appeal.
yes, ma'am.
Government
Three
has
of,
filed.
ma'am, 6 appeals are there.
So government will argue, you will just
lord.
say.
Yes.
All right, let the government argue then.
Yes, ma'am. May I pray my lords to take up WS 608 of 2021.
8 of
608 of 2021.
yes.
Sir, yes,
Come to the straight point why you are challenging that order.
Well,
Transfer order issued
yes,
by
ma'am.
you.
The lords may
will set
turn to
aside.
page 33, the impugned judgment.
Yes.
I will place my lord operative portion, page 37, paragraph 8. Considering the rival contention of the parties, this court finds there is no denial to the fact that there is no such cadre, namely Odisha Municipal Finance Service cadre, as of now, which makes it clear that there is no
Mr.
existence of
Rautre, have you filed the affidavit as asked by this court within a month? You have to file an affidavit.
I filed an affidavit, additional affidavit. They have given effect to the cadre. That is the only affidavit. We have said that though the cadre was there, but was given effect to only in 2020.
Okay.
20.
By the time the judgment was passed, that is in 2009, there was no cadre.
No, judgment was passed in 2021.
The order of transfer.
Transfer. Order of transfer was
Order
passed.
of transfer was passed,
Sorry,
but this
I'm
cadre
sorry.
was not in force.
Yes.
Not implemented. The rule is there, but it has not been implemented.
That is what I was trying to
That
say.
is the only case I have argued before the honorable single judge, and that is
What is
taken
your affidavit? When have you filed that affidavit? Additional affidavit by the respondent. That is the affidavit
Yes, madam.
filed through Mr. Kirot Chandra Rao.
Yes, sir. That is on 2/7/2023.
Yes.
23.
Yes, sir.
Let us
I've
have
given a
a
copy
look
to
into
yours.
this.
Filed on 11/7. 608. Re.
You just see the annexure 1 to their
Of the affidavit.
I think this is the this you are relying on.
Yes.
Rule, man.
Yes.
I have given that rule, my lord. Also, you can find it from that annexure 4.
No, the problem is the rule has been given effect according to them from that date only.
notification.
Yes, you'll also may see that notification, page 39. The rules may be called the Odisha Municipal Finance Service Method of Recruitment and Condition of Service Rules 2017. LSMS 2. They shall come into force from the date of their publication in the Odisha Gazette. LSMS see the just above. It was published in Odisha Gazette on 22nd March 2017.
Yes. But order impugned is it of 2009.
19.
No, 19.
19.
Yes, my lord. So it had given effect with effect from 22/3/2017.
But the notification last para you read?
Well,
They say the migration of the given effect from that date only.
my lord.
Last para of the same notification.
My lord. Last para.
Yes.
more yet.
Annexure A1, the last paragraph, notification at page 4 of their affidavit.
Today's affidavit.
Just just looking at the same notification right now.
No, my lord, I am not.
That was there on the original writ petition that was filed, that same notification.
No, I am
Mr. Raut is now filed.
not-
Yes.
I am not holding that notification. That way I was telling. My
Annex
lord, your lordship may see,
If
I am.
You
Mr.
just
Khulbe will hear me
come
then.
to their additional affidavit at page 4.
Yes, my lord. But this,
If, do you have the writ petition copy? If Mr. Kotia will hear me for
Okay.
good a second, Shunandu. If the writ petition filed by me, that is 14217 of 19, against which he has filed the appeal, Annexure 8 to the rejoinder was the same affidavit, now he is filing. This is a repetition. This was on record before the Honorable Single Judge, basing on which that Annexure A1 I am holding it.
All right.
Taking into consideration that there was no finalization of the cadre, no transfer could have been made, effected. Because we have not been brought in, rule came in 2017, my lord. It was given effect to, but the cadre structure was not completed. So therefore, no transfer could have been effective. That
No, particularly this notification is very categorically, just read the last paragraph.
yes.
Last paragraph.
yes, my lord. Now in
Now-
in
They
exercise,
clearly said the 731 personnel are migrated from their existing cadre to the Odisha Municipal Finance Service cadre as given in the Annexure 1.
That is the first time.
this is the
And all the writ petitioner respondents' names are figured in that Annexure 1.
Yes, only in 2020, but the
No,
transfer is much prior.
sorry.
No, Mr. Khuntia can look to page 45 of his brief. That very notification that has been annexed. Page 45.
Mr. Kuntia, what
See
had
the
happened to
provision.
these employees? They have worked under the municipality during all these years.
Yes, my lord. What has happened, my lord, in this case, they haven't just transferred. They challenged it on the ground that they cannot be transferred in view there is no rule.
They've been transferred where?
They have been transferred to Hindol, my lord.
To
Hindol.
On 6
Hindol municipality or?
Municipality. That's a separate. They have been transferred from Talcher to Hindol NAC.
Oh, which is close by.
So their ground is that they cannot be transferred. There is no rule. That is their case.
No, just Mr. Kuntia, that they don't get so hesitated so early.
No,
There is
no,
some
madam.
other point that will hesitate you more. That at the relevant point of time, whether there was any act which permits the transfer one employee from one municipality to the other municipality.
Yes, that I am showing.
Now, that's number one.
Yes.
According to them, that was not existent. And that is the transfer order is bare in law, and London Single
Yes,
Judge has approved that stand.
Yes, madam.
Now, according to them, the cadre under this Rule 26 of the Odisha Municipal Service Act 2016 was formed the cadre, and the rules are also framed thereunder, but ultimately this cadre was not formed beyond this notification that is dated 14 to 2022.
Yes, but I'll
Only then you can because that becomes the common cadre now to serve all the
Yes.
municipalities.
Yes, madam.
So it can be transferred from one place to other municipality, but that cannot happen in beyond before 14 to 2020.
6/8/19, this position was not there.
Now that is why
That is only
you show
point
that what under what act you have transferred that employee.
Yes, madam. Your lordship may see, I'll show that what are the rule governing the field
Yes.
in 2017.
We don't dispute.
Okay.
Let me finish.
What is the rule?
Your lordship may see page 39 of my brief.
Yes.
Page 39. This is the rule, my lord.
Yes.
This is the rule, but these rules may be called the Odisha Municipal Finance
Yes.
Service Method of Recruitment and Conditions of Service Rules 2017. This illustrates the clause 2. They shall come into force from the date of their publication in the
We are
Odisha
not concerned. We are concerned with the rule 4.
Rule 4. Yes,
Ah.
my lord. Yes, I am coming, my lord.
Yes, yes.
That, why I am showing that rule sub rule 2, my lord. This will
No.
come.
Their contention, Mr. Kuntia, is very categorical. Yes, the rule was there,
Yes, my lord.
but the formation of cadre was not there under rule 4.
I am coming to that, my lord.
All right.
Then, my lord, your lordship may see rule 7.
Yes.
Rule 6 is important.
Rule 6 first you read, thereafter search.
Yes.
6 is my case. I have quoted that also. He is avoiding rule 6.
I am
Rule
not,
6,
I am
rule
not,
6
when your turn will come, you'll say, please.
All right, let him complete,
okay.
Mr. Das.
Yeah, let me say. The Director Municipal Administration in the Housing and Urban Development shall be the appointing authority for all categories of post in the service. The appointment order shall be issued after obtaining the order in the all cases. Then my lord, rules, sub-rule 3.
Yes.
The services shall be state cadre and the officers and employees appointed to the service shall be transferred as per the transfer policy of the deputed to all urban local bodies across the state. Even if my lord, they go anywhere, but cadre, that gradation list has no connection with the transfer.
I'm not getting into that. I'm the authority of the transfer.
The director,
How this gives the authority of transfer?
but because this rule authorizes the director can transfer from one local urban local body to another local body.
Where is that rule?
Rule sub-rule 3, my lord. Your lordship got it, page 41.
No, sub-rule 3 you read also carefully.
The services shall be state cadre and the officers and employees appointed to the service shall be transferred as per the transfer policy of the government or deputed to all local urban local body
You
across
are
the
missing
state.
one very important word, perhaps. I'm sorry to that interrupting you. The service shall be a state cadre.
Yes, my lord.
There is one part.
My lord.
And the officers and employees appointed to the service,
my lord,
meaning the cadre, shall be transferred as per the transfer policy of the government or deputed to the all urban bodies across the state.
Yes, my lord.
So the service means the cadre has to be framed.
Yes, that is the your lordship see that is the cadre at
We want to see the cadre formation notification. That's all. Show us.
No, my lord. Your lordship may say page 40. What is the cadre? Their cadre. The revenue branch of the service shall consist of the following posts, namely revenue officer, revenue supervisor.
Fortunately, it is not cadre formation. Otherwise, you had not published that notification in 2020.
Yes, we have.
You have inducted the persons who are the part of the cadre.
No, my lord. We
You have just explained why this notification was issued. That was also issued under Rule 22.
Yeah, lordship, they are annexing at October 2020. We have prepared also gradation list in the year 2020. Your lordship can find it from.
We are not concerned with the gradation list. We are concerned with the service.
Service.
It means a cadre. That is why I am asking you to carefully read the rule, sub-rule 3 of Rule 7.
My lord.
6.
That is what. Then unless the cadre is formed.
Yes, my cadre is formed.
Yes, cadre is formed. Whether the authority to transfer will be there with this state government.
Yes, my lord.
That is what I am asking you. Show us how the cadre. If the cadre is formed, what is the meaning of this notification which has been issued in 2020?
2022.
2020 notification.
Yes. I could not follow my lord. That 2020 notification is your lordship can
What
find.
is the purpose of the 2020
We have
notification?
prepared a gradation list for the purpose of promotion.
Gradation list.
For the purpose of promotion.
All right, come to that.
My lord,
See again whether it is a gradation list or not.
Yes, my lord.
That is why I asking you you just read the last para.
Yes, my lord. Now in exercising the power conferred by section 22 of Odisha, the service of migrated from the existing cadre to Odisha final are given annexure 1.
So this is the cadre.
Yes, ma'am. This is the cadre.
Comprising of the 771 personnel.
Yes, ma'am. They belong to one cadre. There is no dispute, my lord. Only dispute, my lord, whether they can be transferred. Even what I want to submit, my lord, even if he remains in that either a culture
I
or
have
Hindu.
no confusion. Problem is that something you are stating from somewhere I do not know. He says that they are migrated to the newly formed cadre.
Yes, my lord.
Right. So the earlier cadre, there was no migration, means there was no formation of the cadre before this notification 14 to 2020.
No, I could not follow, my lord, because as per our 17 rules, we have formed cadres. And as per 2007,
just show the cadre formation notification. Matter ends there. You show the cadre formation must be cadre, only can be formed the cadre formation notification. This is the notification. You just see the last paragraph again and again. I'm just showing.
Yes, my lord, I have seen, my lord, that your lordship is saying that because the services of 731 personnel are migrated from their existing cadre.
This is for the first time they are getting migrated to the new cadre.
Even if they are migrated to this cadre, my lord,
if the rules prescribes what would be the post in the newly formed cadre, doesn't mean the cadre has been formed. It shows how to the cadre to be formed and what are the posts that can be brought and migrated to that cadre. Only the cadre will be formed only when this migration is complete.
So what I understand, my lord, that this is the gradation list was prepared.
It is not a gradation list. I'm telling you that. They don't read it as a gradation list. It is a migration list. From one cadre to the other newly formed cadre. You read it again and again. The last paragraph is the key.
I have seen that. Yes, my lord, I have seen that last paragraph.
It's very categorical. There is no ambiguity in the language. It says from the old cadre, they are migrated to their new cadre.
Yes, only to clarify, my lords, I'll take instruction whether this is a gradation list or not.
All right, tomorrow.
Yes, my lord.
Before that, only, my lord.
Heard substantively at the request of Mr. M.K. Khuntial and her counsel. This is in WS 608 of 2020. As the matter will be listed tomorrow as parted for continuation of hearing. This in this case that you show the counsel's name. Mr. Khuntial is for the appellant is all right. And other appeals this in view of the order passed in WS 602 of 2021. That this appeal will be listed tomorrow. We'll decide tomorrow.
My lord.
I think, Mr. Raut, that was your point.
That is the point. That is the point. And the another difficulty is
that notification flows from the rule 6. That rule 6 provides there must be a grouping of persons first, thereafter the migration, and after migration we fall into one cadre, then transfer.
That what falls to Lordship mind. That is exactly the point. That is the point. And you add
Item 43.
Item 29. I'm on VC 29.
Lordship, recollect that by virtue of the Honorable Court's single justice order, we are admitted 2 persons, and they have challenged before in the writ of it, and your Lordship has directed me to check whether any post is vacant so far as the petitioner case is concerned. And I filed an affidavit, your Lordship, see 19/7/2023. In affidavit, your Lordship, see 4 unreserved seat is lying vacant.
My lords,
4 unreserved seat is lying vacant because my lord, after my lord sorry.
Was it party number 2?
Yes, my lord, I am for the university. And I also quoted the also and close the government of Orissa had the education department.
Who is appearing for the education department? Are you appearing?
I'm appearing for the state in this. Admission stage. Admission stage is for your counter.
What are the R3 and R4?
Sorry?
Respondents number 3 and 4. All right.
Officer in charge. તમે બોધે હો કોણ?
No.
Sam.
Who is appearing for the opposite party number 2?
Only 2 I am appearing.
You are appearing. According to you, the affidavit, the post are there.
That is unreserved. That is unreserved because in view of the before see the guideline issued by the government of Orissa Higher Education Department, page 5. With all these seats may not clause 13, kindly have a glance. Next page, 6.
What is the SMS project?
That is the government of Orissa formulated a mechanism so that they are systematically manage the merit list and all these list. There is no manual
Admission into the
any
university courses.
As per completion of the process, there will be no
No, how the clause is applicable in the present case?
Yes.
You said the post, all the posts are the unreserved post.
Unreserved post.
So there is no question of de-reserving the post.
Yes, but he is a person reserved. Your lordship remember putting a question whether any person is above the persons.
No, not that is there. There is separate issue. Nobody is coming to us. We can ask them to just look into this aspect. Someone is coming to us.
Yes.
That I want to get admission. Belongs to the certain reserved category
No,
candidate.
I don't have any objection.
No, there is a two issues is if there was a reserve post, it would be convenient for us to just direction of the.
But suppose
right. But when it's from the general category,
yes,
then only the university authority has to link whether some persons are above him and
yes,
whether
that
they have their interest to get admitted in
that
the.
cannot whether interest or not.
No, unless you find it.
I have given the above persons to the list I have given.
Where is that list?
That is the list. There are so many persons above the petitions.
There is
How many persons are there?
there is no one above me in reserved category.
Yes,
There are
these
lots.
posts are not available under the reserve category.
Let's see, Milord.
Posts are not available under the reserve category.
That is the only problem, my lords.
It is a big problem.
That
This is
is
not
the
a only
biggest-
problem. It is a big problem.
Page 28. Page, you have given 3.
Page 3, your lordship, kindly have a glance for my affidavit.
Just without getting into all the complexities, I just want to suggest that university shall publish a notification or the communications to the persons above him, whether they are interested to get in the admission or not. If they do not come forward, maybe they are also admitted some other places.
Yes,
So
that-
when his turn is come, you
Because
can.
you are in the last part of the year.
That is what. They may not come in this situation. So then if his turn come, admit him. Otherwise, we cannot pass.
Yes,
general
that is the orders, Milord. I understand.
All right, that will passing the direction in this way.
Your lordship pass an order so that the university may issue notice or tell whatever. may be
Definitely. The way the other people who are in the general category be deprived of. If there was a reserve category post, I understand that. Because someone has approached us doesn't mean this is a added qualification for him to get the admission.
Therefore, lordship asked me to file an affidavit
That is
stating
why-
therein
that
that
is
whether
why I
any
want
person
to
is above the
clarify this position. All right.
Only thing is that he
Got
was
my
not
point.
party in the writ.
That is not a problem.
Because otherwise our order will be illegal order.
No, my lord, only
The
point was
action
that he
is
was
when
not
the
a writ
first-
petitioner, he was not a party in the writ petition below, so he has challenged this writ application.
That
Writ
is
appeal.
Maintainable.
Maintainable, but that part only.
All right, that part will be checking up now. What is that order? Annexure 1.
It's not a party and there are other persons who will be deprived also.
Who has been deprived? No, counter was also filed, it was disposed of on the first date.
Like spot selection with the High Court.
Kishore Kumar Das.
59.
59.
What was there, the two persons who's the petitioner, writ petitioners? This. What was their position?
My lords, it's not all.
One is Shumon Malik.
Sumant Malik.
With the writ petitioner.
No, he was the writ petitioner.
Yes.
Sumant Malik was the petitioner in
His
the
rank
read petition.
64. His rank was 64, my lords.
Below you?
My lords, below me. My rank was 59. Ignoring me, he has been given
So we are
admission.
interfering with that order because this cannot be sustained. Because someone in merit position below him is directed to be appointed, excluding him, then we have to interfere. Whether the person has been already
No, because we are admitted because this honorable court directed me specifically to admit him.
Two persons,
Two
not one.
persons,
I think two
directed
persons.
specific direction. There is no
Specific direction, my
such
lord.
thing,
There
but
was no
is
specific direction, my lords. Well, a similar direction as per my instruction. I'm not 100% sure.
No. I think
Similar
there is
direction was also
specific
issued
direction.
to ULC,
Specific
Utkal Law University, but they applied their mind, they denied the admission. There was no,
But what happened in the Madhusudan law?
ma'am, my lords, they gave admission to this
Where
person.
is the
my
order?
lords,
There's not a direct order. It is for them to consider.
Lordship, see the order.
No,
Lordship,
I think it was.
specifically. Not to not be a precedent, everything has been specified.
Who is appearing for the opposite
At
person
page
number
14.
4? Was
my
it
lord, the
noticed?
language is, if decided to be given by the authority, shall be confined to the two petitioners. If decided.
If decided, okay.
So you should not have decided.
No.
Or else if you decide,
Total
if you want to
paragraph has to
comply
read,
with the honorable court
You
order,
read the
Start from
paragraph.
paragraph
and
6.
Yes, read the paragraph.
Totality, Millard, it will be understood better.
So this not to be a precedent is another day.
May I please.
You read para 6
Yes.
only.
Para 6.
In such view of the matter, the court deem it proper to dispose the writ petition by keeping in view the peculiar fact and second the present case, and further taking into consideration that seat are lying vacant in the college in the question. The authority party opposite 1 and 2 are hereby directed to consider the case of petition sympathetically. In event is found seat are lying vacant, the petition may be accommodated by giving admission under this category, spot admission. And further, it is made clear that the benefit spot may be decided by giving authority shall confine to two petition only and be done as expedient as possible people within 2 weeks.
that is the my lord's word, if decided. And my lords, if decided is the my lord's word, then the proper procedure should have
Now,
been.
since you
for the
have
above
appointed
persons.
them,
Then you.
just wait, since you have appointed them, now I think he has a very positive right to exercise. You have to appoint him also.
Yes, no, I have no, I'm not.
Appoint him.
Yes, you lordship
Always.
that direct, you lordship direct, not I don't have any
All
objection from first day of day 1 I'm saying so.
All rich.
Mistake has been made, Lord, that has to be.
They have consideration, they have appointed whatever. And he's above the merit position. He will be the patients of. There's stated in the affidavit. You are Mr. Vidyabhushan?
My lords.
Third, Mr. No, that obviously, but we analyze that this kind of a direction.
Why would it
This
be done?
is casualties also. Appearing for the absolute. So, we have also heard Mr. T.K. Satrapathy, Learned Counsel, appearing to the responding number 2, and M.S. S. Patnaik, Additional Government Advocate, appearing to the respondents number 1 and 3. Right? By means of this, we read intercourt appeal. The order dated 9/1/2023 was by the Honorable Single Judge in WPC number 34262/2022 has been challenged on the solitary ground that the opposite party number namely Shuman Malik, who is occupying the merit position number
64, my lords.
the general position, intercept position
My lord, SC position 64.
in the merit position number 64, and another person what is his name?
You've not made him a party.
He's above you.
My lord, she belonged to general category. I have no grievance against her.
All right, all right.
There is no problem.
So, in the merit list for the scheduled caste category, stop. By the impugned order, learned single judge has directed for consideration of his admission in the LLM course in the Madhusudan Law University at Cuttack. So, the appellant was not impleaded as a party in the writ petition has been occupying the merit position number 59.
59.
Merit position number 59 in the said merit list for the scheduled caste category. The opposite party number 2 had informed us that after the date of admission was over, the two persons, including the opposite party number 4, was appointed in the exercise which was taken in terms of the impugned order.
Spot admission.
Huh?
Spot admission.
By means of the spot admission. Stop. By the order dated 23/6/2023, we allowed accommodation to opposite party number 2 for scrutinize and ascertaining the vacancy position vis-a-vis the reserve category, etc. Mr. Sadhgopati Learned Council has submitted that. So, this affidavit has been filed on 16/7/2023. Stop in the said affidavit. It has been stated inter alia as follows. Quote para 2 and 3. Except the Xerox copy of the merit list, this part should be there. It is apparent that there was 4 vacant seats in the category, in the general categories were available, and in compliance to the impugned order dated 9/1/2023, the Madhusudan University has admitted 2 students, including the opposite party number 5. Stop. Including the opposite party number 5. Stop. It may be noted here that the writ petition being WPC number 34262 of 2020 was filed by the 2 petitioners, and one of the petitioners belonged to the general category. Mr. Vidyadhar Learned Counsel has categorically stated that this present appellant doesn't have any grievance against the admission of the candidate who belongs to the general category, right? Stop. The appellant's prayer that since he occupies the higher merit position in the merit list for the scheduled caste category, he cannot be superseded by the opposite party number 4 so far the admission is concerned. And simply because he did not approach this court, his right cannot be diminished. After having the knowledge, he has approached this court by filing the present appeal. Stop. Stop. Since all the vacancies, as referred in the additional affidavit filed by the Madhusudan University, it appears that belong to the general category. And the Madhusudan University has admitted opposite party number 5, whose merit position is far below the petition appellant. We think for this process the appellant has acquired a right to admission. As there are 2 vacancies are still available, we direct the respondent number 2 to admit the appellant in one of those vacant posts as he has been superseded at the time of the so-called spot admission. Stop. And such admission be provided within a week from today after complying all the formalities as required for such admission. Before parting with the records, we are constrained to observe that while passing a direction in regard to the admission, all the relevant facts are required to be laid before the court, so that court is not persuaded to pass any order which cause exclips of the existing rights of any student desiring admission in a particular course. As such, the order of the learned single judge as well as our order shall not be treated as precedent in future. So in terms of the above, this appeal stands allowed.
May I make a small, my lords, one innocuous prayer, my lords. My lords, as lot of time has elapsed in between, so my lords, the university may consider after I take admission to means arrange some classes so that
This cannot be done. You have to study hard and you have to go to the other coaching also. That we cannot do. Otherwise you don't get admission this year, try for the next year. That we cannot direct. Sorry.
Obliged. Deeply obliged.
University are limping because of the shortage of the faculty members. We will not create the extra burden for them.
Obliged, my lord.
Yes.
Deeply obliged.
What happened? Ask them.
Memo
You did not send the memo to him? Already look into the matter later after the court. Two 40 days delay. You have Miss Gudguti here.
Yes, Lordship.
Heard MSS Gudguti here, Learned Counsel. First, the matter is taken up on special notice. This is in IA number 4774 of 2023. Yesterday. This is an application for condonation of delay This is an application for condonation of delay. According to the stamp reporter, the delay is 242 days in filing the intercourt appeal from the judgment and order dated 1/11/2022, delivered in WPC number 22822 of 2020, titled as TOV versus NCT and others. Stop. Issue notice as to why the aforementioned delay. Such and such notice is made returnable on 4/9/2023. Steps for service on the opposite parties shall be taken. You can serve on the under order 27. You can serve the copy to the opposite party number 2 in the office of the Deputy Solicitor General of India.
Yes.
Already, the applicant may complete the service on the opposite party number 2 by serving a notice on the Deputy Solicitor General of India, High Court of Orissa. So along with that notice, a complete set of memorandum of appeal and the miscellaneous application, including the present application for condonation of delay, shall be supplied to the office of the such and such, Deputy Solicitor General of India, Cuttack. So however, the petitioner shall take steps for service of notice on the opposite party number 1 by registered post to EPD within 2 days from today by stop.
Lordship, can I pray for a stay of part of the or impugned order because public exchequer is involved? The officer has been joined, has been allowed to join as per the order direction in the order, Lordship. But the back wages, huge money is involved, and if that part is stayed till the disposal of the appeal,
Let us see the order that we have not seen. It technically passed the order since there is a delay.
Order has been passed in November 2022.
Lordship.
So why have you come now?
Lordship, I have tried to explain, Lordship, what happened since the public undertaking is involved. Policy decision had to be taken, and Lordship.
So after such a long delay, we cannot pass a stay order. We can
Part of the order. Lordship, only back wages. He has joined the service. He's doing work. He's getting current salary. I'm told only the back wages part, Lordship, because he is putting pressure for that. Only back wages, Lordship. Till the disposal of the appeal, and we will not delay further, Lordship.
I'm not getting the what that facility.
Lordship, the officer was charged, unfortunately, was currency was found.
Stay application separately.
Lordship, yes, separately, Lordship. The bulky one with all the annexures, number 4773, Lordship. And 4774 is for condonation of delay.
Oh, yes. But this is here. Just I'm showing you the application for the stay. Please see. Where is the application? Page. This is the application of stays written here.
So that's
That IA 4773 of 2023. Heard such and such. This is an application for staying the operation of the judgment in order dated 1/11/2022. as impugned in the connected appeal being WA number 1769 of 2023. Issue notice returnable on the same date. What clause you want to stay?
Lordship, the impugned order, the page 164.
You have made a mess in the paper book. Because after the memorandum of appeal, we are getting your stay order. That is not the way it is filed. Stay order is a separate entity. They should be filed separately. This is put inside the paper book of the writ appeal.
Lordship.
It's not done, and that is why these people are finding it so difficult.
Reinstatement with all full baked wages and continuity of service. So full baked wages part, Lordship, only.
You have also not filed the certified copy of the judgment.
Lordship, I went for the filing and I've applied online for the certified copy, Lordship, because the
Please
earlier
try on the
advocate.
next date. This will not do it. Try on the next date. Nothing would happen. No contempt has been filed against you as yet. That we have issued the notice on the next date, you come with them. Because they may also appear, the private person also may.
And whatever irregularity, if there is any, I will try to, because at the time of filing, it was
Go
not
out and in the main writ
pointed
appeal,
out.
you saying the defects as identified by the registry shall be removed within 7 days from today. All right.
I mean,
Now that you.
So it will appear.
And you take steps in this regarding the condonation, one notice to go, other you serve the notice in the office of the Deputy Solicitor General of
Lordship.
India.
Grateful, deeply grateful.
I will pardon. Item 37. I have one matter in the last 27/7 when it was listed, my name, my matter was there. Writ appeal number 1655 of 23. It is delisted. It has not been tagged to this voice of cases, though it was initially tagged. And but in that my case, my lord,
just give your number that will be tagged.
Once I'm giving
Just give-
1655.
Just give a sheet of paper that will.
Yes, yes, I'm giving.
That is the Dutch matter, W. That is that part. This,
Yes,
municipal cadre.
Yes, 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 ma'am.
Already.
1655 of
Who has taken this
23.
order, municipal cadre order?
No, not municipal cadre. Sorry, ma'am. This is against another. This is another case. Item 37, ma'am. Ravensa College matter.
Oh, all right.
That because I'm going to be terminated by virtue of the impugned order.
All right, just add this matter with this, huh? This just, huh? No, we are not fixing the date. Date will be given after looking at
But
the.
in my case, my problem is no interim order could have been passed on the other day. Other cases, interim order passed. This was my name was not reflected. The case was there.
The
That
records is not before us, Mr.
No, it was there, my lord. I'm just saying them. Let it be
Now
tagged
you
to-
are saying it is there.
Yes.
You are
No,
supposed
other
to.
day, my lord, my
Mr.
constituent
Das,
parties.
Wait.
Yes, yes, sir.
Wait. Always the loud voices doesn't carry.
My voice is like that,
No,
my lord.
it is we are very fond of hearing your voice, no doubt about it. But problem is the record is not placed.
I
to
know.
us. You could have mentioned the matter is at 10:30.
I thought it will reach. That is my problem. Anyway, my lord, what I beg to submit, my lord, can it be?
Separately list this matter tomorrow. And matter will be listed tomorrow.
Yes.
And you then, when you just collect the date of this batch and then we'll tag with that batch.
Obliged.
All right. You list this matter, only what sleep with this matter. Other dates will be given by the court.
Your lordship, the matter will come tomorrow, 37.
Das, is your matter there in the list today?
The matter is,
nice,
the matter will
that's
come in
earlier.
tomorrow, your lordship, the 37.
The entire batch we cannot accommodate. So we will be fixing another date for that.
Item
The short date you are trying to find out a short date that will be provided.
Lordship, item 36 perhaps. Item 36, Lordship, kindly say 36, Lordship.
So after today, there will be certain space for us because in
I
the
know.
last date of the hearing of this commercial division.
I know, but the Lordship, kindly say 36.
Ah.
36 is a national law, which is the appellant, Lordship.
Okay,
Tomorrow-
fix this matter in third. Third.
Lordship,
Tomorrow,
great.
third,
Item
Lordship, grateful.
32, my lord. Item 32.
Want
Third,
to,
just two days matter and third. Huh?
third is tomorrow.
No, at two, whether any matter has been fixed on third, huh? At 2 p.m.
Grateful, Lordship.
Item
Pardon me,
32,
lords.
item 32.
Huh.
Now this is relating to filling of the posts of 170 assistant station officers in the fire department. Well, since there is an interim order, we are not in a position to fill up those posts. We have also filed an IA for vacation of the
14th August.
at 2 p.m. your lordship.
At 2 p.m. There is another matter is 2 p.m. Just you mention on that day, we'll upgrade it. All right.
Beg your pardon me, lords.
14th August, I will not be there. I am in that case. Can it be either earlier or
Either earlier, your lordship fix it to prior to
14th August.
When we are ready for tomorrow and day after.
Yes, tomorrow your lordship.
It can be problem also.
Tomorrow or day after.
We want also.
Tomorrow
Can it be
is
on the
61.
4th
We are
August?
ready. Your lordship heard that.
Lot of matters are there, but whether accommodated.
Actually,
Just let them update, list the matter on 4th of August.
4th of August, yes.
And
And
we
we
try, you do not know what will happen on that day.
then we will take our chance.
Beg your pardon me, lords.
First of
One
Friday.
star we can say.
Already this we can manage it.
Beg your pardon me, lords.
Fix
Item
a time.
30
The interim order to
Item
continue that.
37, lordship calling tomorrow. Item 37,
No, it is-
Revensa matter.
It is, date will be given, right? Date has not been given, it will be given. After the position of the board, that date, closer date will be given.
33, my lord.
I am on DC, my lord. 32 minors,
Ah.
interim order to continue.
32, yes.
Right.
37 as well, is lordship.
Item 30.
Just a minute, the interim order where it is to be continued, these orders will get the priorities.
In item 37 also, there's an interim order, your lordship.
32, give a date. Huh?
Tomorrow, no? Sorry, day after tomorrow.
Fourth. Just this, just you list the matter on 4th. In every matter, interim order is there.
Yes.
Interim order is passed, it will continue. This 2-line order, yes. All right.
I beg pardon, your lordship.
But it's 33, my lord.
Item 37 also, there's an interim order, your lordship.
Interim
all
order
orders are
will
interim
be
order.
continued. After the date is there, interim order will continue.
My lordship.
37 also take note, interim order.
Right, item 33.
Kind
Item
permission,
33, my lord.
Item 53. My lord, kindly, this is case, my lord, about the assessment of the child of autism. My lord's kind permission, it has been done.
Miss
And
33.
the AIMS recently has ruled out that is a case of, my lord, autism, and his medical attention is required. Today, my lord, may not be taken, lordship may fix to, because the chamber lordship are taking the matter, both parents and the child. If, my lord, there is no
Today
notice.
is not possible because the
7th, as you lordship.
7th, 8th, you just, 7th, 8th, 9th, you forgive us because for certain other reason. May it be 10th of August. 10th August. It will
10th
come.
August.
Just 15th.
Your lordship, item
Oblige, kindly direct to reflect about the appearance of the parties.
All right. 53, just pass the order and then item 10.
Your lordship,
Your
item
lordship,
38.
To appear
Right.
in person.
Oblige, my lord. Grateful.
Your lordship,
My lord, I pray for tomorrow, there is Konark temple photographers unrest matter, my lord. Can be taken up tomorrow, my lord. Only one, any
Cannot
date,
be.
your lordship.
Cannot be.
Next week, any date. Because interim order is operating against us.
11th. Fix on 11th August it will come.
Your
11th.
lordship, item 38.
Any day, Mr. Palit is not there when 10th and 12th.
11th.
11th. That is
Lordship
why
said
you
11th.
fixed on
11th.
10th and 12th, between that he is not there. That is what
Eh,
I'm sub.
9th, your lordship can. 9th, my,
After 12th,
if possible, 9th, my lord. Because my friend is enjoying interim order.
No, why 9th it cannot be. Then we are fixing on 14th.
But may I pray for little earlier, any date 4th, possible.
Yes, every day that we are stopping somewhere,
But-
we are fixing again the matter. That is why we are
My
just.
lord.
But if possible, 7th, my lord, because 154 persons are obstructing us, my lord.
7th also the court will not work for the entire day.
my
There
lord.
is a
8th, may I
issue.
pray for 8th, if possible.
8th also it will not be done. Rather you fix on 9th, one matter, no? It will come on 9th of August.
9th of
Your lordship, your lordship,
This is
item
your matter
38.
is- Konarak matter is item number? Your item
33, madam. 33, madam.
33.
Your lordship,
Item
item 38,
item-
interim stay to continue and the date please be
All
fixed.
right, 38, give a date,
A date be kindly be fixed.
28th of August, entry order is passed earlier, shall continue.
Item 31, interim order is till date, ma'am.
Your
All right,
your
same
lordship,
order.
the date of item 38.
28th of August.
And item 35,
Your lordship, interim order to continue.
Ah, that we have passed the order, don't worry. 30
Item
is-
51, your
Item
lordship.
41, 45 and 46.
41, 45 and 46, same date. Interim order shall continue, okay?
If my
Well,
lords
I
will
would
kindly pardon me,
receive-
that item 33, my lord, has been kindly 9th of August. Interim order is there, that may kindly be continued.
33 is 9th of August. Interim order is passed earlier, shall.
Item
continue.
51, your lordship. Item
33 is also
51.
the interim order, huh?
Lordship, item 51. Interim order is till date. Till today. That may be continued. Government has to file counter.
51,
51 errors.
and date 51. Thirtieth August.
Your-
Interim order, if any is passed earlier, shall continue.
Your lordship, item number 55.
Till the next date.
Item number 55, last one. Your lordship, short date may be fixed.
Why?
Item number 55.
Why short date?
Lordship, today this matter has been fixed for hearing, your lordship.
Right. You fix a date in this month only.
60 matters fixed.
So it will come on 30th of August.
Oblige, your lordship. Interim order to continue, your lordship.
Interim order is passed, if any passed earlier, shall continue. All right.
My lord, I am on VC, I may be pardoned. Item number 29. Item number 29, my lords.
All
I am
right.
VC. That matter, your lordship, this person is going without, he's not getting his pensionary benefit also. He has worked for 37 years and his ad hoc period did not regularize, against which I prefer this writ appeal. He was satisfying all the requirements, your lordship has issued notice. So I pray any date it may be taken up, short date, day after tomorrow, or and a counter
Not
may be
possible, Learned Council, not possible. You have to wait for further dates. We are trying to accommodate you. You come on 30th of August. Because there is prayer on limitation has not been decided by the court as yet.
Your lordship, they had issued, earlier Chief Justice has issued the notice in the main case and we have served 6 copies. So that formal order of condemnation of-
That is a little bit of we are facing some trouble because of this. That if you have the notice on the appeal which is barred by limitation, the first, unless we just remove that bar, we cannot enter into the appeal on merit. But
He had
you do
suffered
not
a
have
brain
any
stroke.
problem with the service of notice. I think, yes,
Yes,
Mr.
I've served
Tuli,
6
are you
extra
appearing
copies.
in this appeal? 29.
I think all the opposite parties are government officials.
Yes.
All right. How much is delay?
53 days delay. He was suffering from brain stroke. And yes, I have given that application with all the
There is,
medical.
Mr. Mudoli, there is no delay.
No, madam, but during that,
This is your judgment.
during that COVID period.
Yes, yes.
There is no delay.
Yes, that I am
So it will come
submitting.
for fresh admission. You can be disposed.
This is an application for condoning the delay, but there is no delay according to the stamp report. And thus this application has become inessential and hence this is disposed of. Stop. The appeal can be heard.
Yes, madam.
You remove the defects, Mr. Rath. There are some illegible copies.
The illegible, I have given a service book. That is some type
type
of.
it.
Appellant shall remove the
Don't rely on that.
defects as identified by the registry. Let the matter be listed on 30th of August 2022
Fresh admission.
for admission, and there shall be an attempt to hear the matter finally
Yes, ma'am.
on that day. All right.
And 6 set of extra copies has been served and the receipt has been filed.
All right, they are not claiming any extra copy. All
My
right.
My lord, my lord.
All
Okay.
right.
My lord.
No, sorry, again to the- Yes.
I'm
sorry to be once again going back to the housekeeping issue, but I think Loshes had indicated yesterday that you could give us half an hour in case required. I don't want to.
I hope it will not be required. You know how to conclude rightly. We know that.
Well, I'll try my best, Lord.
Yeah.
Lord's confidence in me is more than my confidence in myself, Lord. But certainly, Lord, I'll try and do my best.
You
I
can
was
do
at
that.
1845. Kindly come to 1845.
Yes.
That'll be volume 4, 1845. This was on the issue, my lord, as you lordships recall, of claims on the basis of breach of warranty or defect claims, if you may call it, defect claims, where GKEL claimed that some machinery or services provided by SEBCO were defective and they were breaching, my lord, the warranty obligation.
Yes.
Now, I had shown to my lords yesterday that warranty was for a period of 12 months, ending in June 2015, and that's the common ground, an admitted fact before the arbitral tribunal. So the warranty, my lord, began in 14, ended in 2015, my lord. Now, my lord, please see how the tribunal analyzes this argument of the party, or this case of the parties.
Yes.
Kindly come to 1845. Please kindly come to 1337. Para 1337. The respondent's claims arise under section 10. A defect is defined relevantly in section 1 as in, but it defines a defect, not please skip that. Kindly come to 1338. The claimant warrants in section 10.1.15 that in the event any defect are discovered in any of the components of the power station or any unit thereof, such defects shall be remedied by the civil contractor at its own risk and cost. Now, please mark that plot. Please mark the words that follow during the warranty period. Argument that is made before your lordship is that plot, the appellant claims that, well, the tribunal holds notice was not required. I did not give a notice in respect of warranty, but yet the tribunal has denied my claims on breach of warranty. But as far as breach of warranty claims are concerned, the lordships would find from the analysis of the tribunal says these are time-bound warranty. It's not a running warranty forever. It's a time-bound warranty. Now, please see, my lord, 1339. The respondent must promptly notify the claimant if any defect comes to its attention. And in order to be effective, section 10.3.1 provides that the notice must be given by the respondent at the latest within 45 days after the end of the warranty period, or if applicable within 45 days after the end of the extended warranty period, that such defect or deficiency has arisen within the warranty period or the extended warranty period. So therefore, the defect must arise within the warranty period for it to be, my lord, invoked, and for the claimant, that was my client, be, my lord, called upon to remedy it. 1340. It is clear from these two provisions that any defect must be discovered during the relevant period, and that the respondent must give notice of any such defect at the latest 45 days after the end of the relevant period. These two mandatory elements are emphasized by section 10.2, which begins, if the owner notifies a civil contractor in writing with reasonable detail. The clause then sets out warranty obligations on the civil contractor to reperform any of the works or to repair or replace any defective or deficient materials. This construction is consistent with the conventional position as summarized in Keating on construction contracts as follows. If the contractor is not in possession of the site, then in the absence of the express terms to the contrary, notice of defects is, it seems, necessary before it can become liable. And if the employer, without giving notice to the contractor itself, corrects defects, it cannot rely on the defects clause as against the contractor. The tribunal accepts the claimant's submission that the respondent must demonstrate the evidence of, existence of a defect within the stated warranty periods and must also notify the defect within the extended warranty periods. Both requirements must be established before the liability arises. I'll pause here for a moment. A, is this an issue under claim 2? It's not. B, it is an issue with respect to breach of warranty. Now, my lord, for a breach of warranty, but please forget what the tribunal has analyzed and held. Is it not normal, reasonable, rational, commercial conduct of a party that if warranty is breached, it will notify the person who's to rectify the breach, versus you are in delay, you are not in delay. Now, my lord, unless I know that something that I have done has gone wrong and I am required to rectify it, how will I rectify it? So no notice in a breach of warranty situation, the tribunal says doesn't apply. Tribunal says for breach of warranty, the respondent was required to notify the claimant within the warranty period. Third, warranty, my lord, is not a running warranty forever. It is a fixed warranty period for 12 months or extended warranty wherever it's applicable. So therefore, my lord, I am liable only to rectify the defects that arise within the warranty period, not, my lord, something that is raised or invoked or claimed much after the warranty period is ended. Then, Lord, it goes on from 1343. Because I have very limited time today, my lord, I will skip, but please note the paragraphs, my lord. 1343, 1344, 1345, 1346, 1347, 1348. The tribunal has analyzed in great detail the evidence, the documents, the pleadings, and the law. Now, my lord, with utmost respect, I submit. In view of this, can it be said can it be questioned before Lordship's, my lord, that this was not an issue before the tribunal? It cannot be. Can it be said it is synonymous with the delay claims? It cannot be. It's not synonymous. Chalk and cheese. They're different. Can it be said that the tribunal has rewritten the contract? With utmost respect, no. And even if the answer to any of this is a yes, that's not the 34 test. And these are not my words, my lord. These are words from the Supreme Court and of this honorable court. I am not running away from a factual inquiry, but that's not required. Your lordship would never call upon a factual inquiry in the 34. I have answered to everything what they've argued, but all of it, with utmost respect, your lordship would look at the substance and not the form. Please don't go by the phrase that was again and again cited and invoked before you. It must shock your conscience. What must shock your conscience, my lord, with utmost respect, is an attempt to invite you into a factual or evidential inquiry in a 34. And that's why I gave that analogy, my lord, of the soothsayers. They said the same thing, but in different form. But what is important is, as a court of law, your lordships would reject the form and look at the substance. The substance here is, your lordships have been called upon to look at, my lord, emails, to look at letters, form your own opinion. Is it waiver? Is it not waiver? 2010 series, independent of 2012 series, completely wrong argument. Now, my lord, please go further. 1858 now, in the same volume, my lord. Now, in this context, those two paragraphs that were identified before your lordships, my lord, by the appellant, the tribunal concludes these are defect claims. Warranty was not invoked in time. It was not, my lord, therefore applicable, and the claimant is not liable. It's a construction of the contract by the tribunal. It may be right. It may be horribly wrong. Even if it is horribly wrong, my lord, it is outside the pale of 34. But please see, my lord, 1405. 1404, 1405. A digital electro-hydraulic turbine governing system may be very reliable, state-of-the-art, and does not require a hydraulic backup system. But that is what was agreed to be supplied, and it is no answer to say it is not needed for the operation of the power station. It is an omission in the works, but there is no liability, as the respondent did not give the requisite notification of the alleged defect. Losses have 1858 plot. Yes. I am reading 1405. There is no liability unless a defect is shown to exist in the requisite period and that the contractual notification of the defect was given to the claimant during the relevant warranty period. These two elements are essential regardless of the nature of the alleged defects. Now, my lord, please have the second paragraph that was identified. Can you turn the page, my lord? 1408, 1407 to 1409 below. The respondent submits that as the alleged defect relates to a deviation and or omission from the works, no notice is required for this defect, as the claimant must know when it constructed. Not 1859, page 1859, paragraph 1407.
Paragraph number is
Not 1407, my lord.
Respondent submits. This starts.
I'm so deeply obliged. I'm so grateful, my lord. The respondent submits. Lord, I must say, my lord,
yes,
this is Panigrahi has taken to, my lord, the technology like a fish to water.
1407.
Now 1407.
Yeah.
Lord, and now even, Lord, although, my lord, it said that we work on this a lot more, but even now we find it not difficult, so I'm still using paper. But I see with what alacrity you're reaching, my lord, 1407. I'm grateful, my lord. We must learn from them, from your lordship's, my lord. 1407. The respondent submits that as the alleged defects relates to a deviation and or omission from the works, no notice is required for this defect, as the claimant must know what it constructed. Claimant's position. Alleged defect was not notified. There is no liability unless a defect is shown to exist in the requisite period and contractual notification was given to the claimant during the relevant warranty period. These two elements are essential. Tribunal's analysis 1409. It is an omission in the works and a defect, but there is no liability as the respondent did not give the requisite notification of the alleged defect. There is no liability unless a defect is shown to exist in the requisite period and contractual notification was given to the claimant during the relevant warranty period. These two elements are essential regardless of the nature of the alleged defects. Now, Lord, I can very fancifully, as the appellant has done with utmost respect, compare chalk and cheese and say, well, chalk is being discriminated because cheese is being preferred. But lordships would look through that argument because chalk and cheese are different. So every way the tribunal, with utmost respect, Lord, these are three arbitrators who have rendered a unanimous award, and three arbitrators, Lord, and by no means should it be, Lord, a parameter for justifying the award. But these three arbitrators are world renowned in their respective fields. They hold great scholarship, and I say so even for the nominee, Lord, of my friend's client. They hold great scholarship, Lord. They've heard the parties over 2 years, applied their mind, heard evidence, and then decided. Now, my lord, so therefore, the argument, my lord, that the tribunal has treated the parties unequally is an argument, with utmost respect, of sheer convenience and no more. It's an argument that is misplaced on facts and devoid of legal merit. It is misplaced on facts for the reason that it is comparing chalk and cheese. And it is devoid of legal merit for the reason that at the very highest, this argument is outside the pale of 34. And if it is outside the pale of 37, it can't be brought into 37. In 34, it can't be brought into 37. 37 is still narrower. And these are not my words, Lord, these are the words that lordships have given in your lordship's judgments.
Yes.
Now, Lord, I must also deal with an aspect that was put to me, and I am so deeply obliged because that is a very important question. Although, Lord, my answer remains, if I may say so, Lord, a parrot-like answer, that not this is outside of 34, and that is an answer that I am bound to give as your lordship's officer, because I must inform your lordships and I must assist your lordships, Lord, to the extent that I can and should, not about the relevant legal position, and which is that all of these are aspects outside. But the lordships put a question to me that the argument made by the appellant is 2010 was the bulwark, was the universe, if I may say so, of my plea of waiver. I have shown to my lords it was not. 2010 and 2012 both were pleaded as instances of waiver. They were incidents, my lord, over a certain period of time when the contract was being worked. In a sense, they were related. In a sense, they were independent. They were independent because they were independent acts at different points of time. They were related because, according to me, there was a consistent conduct. The tribunal appreciates evidence and says, well, from 2010 events, I cannot infer within rock advertising, within the test of rock advertising, I cannot infer a written exchange which gives rise to a waiver. But I find from 2012 that the claimant has been able to establish a written exchange where the parties have told each other that we will not insist on notices with respect to the delay aspects. And Lord, I ask myself, was it not the managing director of the respondent who came into the witness box to say, yes, we agreed to not send notices to each other? That was Mr. KVV Rao, my lord. I read to my lord's my lord his evidence. Who other than the claimant, than respondent's own witness, my lord, saying, yes, we agreed to not give notices on these aspects in the spirit of cooperation. I acted on it. You have acted on it. Therefore, my lord, I had shown to my lord's my lord the evidence of KVV. I had shown to my lord's my lord the evidence of Mr. KVV Rao and my lord what he says in his evidence affidavit and what the tribunal analyzes. Now, Lord, assume for a moment the tribunal was horribly wrong. Not wrong, palpably, horribly wrong on appreciating the aspects, correspondence, evidence, readings that the parties had made before it with respect to 2012. Lord, but that's not even the test that Lordships would go into, my lord, with utmost respect, for a domestic award. And I'm going to show to my lords, my lord, and I will bring you back because that's how, my lord, I would like to end if Lordships permit. That what Lordships have held as a 34 court, as a 37 court, that even, my lord, a finding, and that's what associate says, which has been further made stricter. But associate para 33, my lord, says a finding without evidence is also good enough. Lordships put a question to me that there is a difference. Although as the court's officer, I must say that I can't argue before you a finding without evidence must also be, because not that's my thought process. But as a student of law, my lord, I am bound by what the Supreme Court says. And Supreme Court says even a finding without evidence should not be disturbed for a domestic award, my lord.
This statement, the judgment of the Supreme Court you are referring to, it is qualified by so many other reasonings.
I will show that also to my lord. I'll show that to my lord. That's not even my argument. That's not even my argument. I'm not saying please even in any given situation, please uphold an award which is without evidence. But my lord, evidence or lack of it are all, my lord, if I may say so, not subsets of patent illegality. And I'm not running away from answering a question of fact. I'm answering them. I have answered them to the best of my ability yesterday, and I'm answering them today, my lord. But, my lord, the only question, with utmost respect, I have repeatedly put to myself is this, that an award which spans over 300, 400 pages, my lord, which looks at pleadings, which looks at documents, which looks at evidence, which has adjudicated the issues. But is this an award? Is this an award as an international commercial award, which can be said to be an award so shockingly without evidence that the appellant can be allowed to incorporate, although the legislature has taken out that inquiry, but the appellant can be allowed to incorporate by some legal jugglery the test of patent illegality and invoke it and have it applied but not successfully. My endeavor has been to show to my lords, my lord, that all these issues were before the tribunal. The parties were at issue on them. They had their own position. They led the best evidence that they could. And the tribunal has adjudicated them on the basis of the evidence that was before it. Once, my lord, there is evidence. Once the tribunal has given reasons for its findings. Once the tribunal has, my lord, applied its mind to the cases, respective case of the parties, where then, my lord, is a question I ask myself, my lord, of not arguing, of the appellant arguing that the award must shock your conscience. Now, my lord, one of the aspects that was relied upon again, and my respect submission factually inaccurately again, was that customs clearance was allowed. Claim on customs clearance came to be allowed. Now, please have, my lord, to save time, please have my note 1, that the note that Luscious had with you yesterday. Please have that, my lord. And if I may invite my lord's attention to paragraph 40 at page 12.
Okay.
40, my lord, at page 12.
Yeah.
Internal page 12.
This is 10, it's I think 12 page. Here in my note it is 12. Para 40 is in 12.
But the very first note that I gave,
Yeah, this is the
which
this is
says
part 1. No? This is part 1 note.
That's right, part 1 note, my lord. Kindly come to page 12. Just above 40, you will find a subhead which says SEPCO did not
SEPCO
provide
did not
notice.
provide notice. Yes.
That's right.
But
This is that
paragraph-
subject that I am
the page
addressing.
is different.
12.
12 in our our night page is jumped.
I'm sorry, my lord. It is very difficult situation to be in if the court and the lawyer are not on the same page.
12 actually.
I'm saying, my lord, in lighter vein, it's a very difficult situation to be in when the court and the lawyer are not on the same page, my lord.
There is only a story you may not be knowing. There is a poet named Jayadeva who wrote the Gita Govinda.
Geet Govind.
So Geet Govind. So where he used to write, sometimes he could write, stop somewhere. He used to sleep. In a somnambulist state, he used to write.
Oh, wow.
So maybe pages may have been done in a somnambulist state.
That's right. That's right. Because all these notes have been prepared in the dead of the night, I must say.
No, maybe I think the font size was changed and the pages
That
increased.
changes
I'm so
that
sorry.
also.
Because
so
they
sorry,
thought
bro.
the judges are old, particularly me, not the young judge. Read the small font.
No, my lord, neither is your lordship old, nor is my lord the other member of the bench, my lord. But I'm sorry, my lord, if there is confusion.
Now
on the page
this can
number.
make it
But
bigger.
please have para 40,
it's
my
no
lord.
problem.
Please have para 40. I hope that number has not changed.
Yeah, para 40 is there.
The appellant has argued that the 80 while deciding issue 5, customs clearance. Mala sir? Customs clearance has held that SEPCO had not given notice, but yet relief was granted to SEPCO on the basis of breach of implied terms by GKEL. I'll pause here for a moment. Not if losses are shown one side of the coin and losses are told there is no other side of the coin, would losses believe it? No. Losses would not, because the coin has two sides. Now, please see what losses have not been told. Please see 41. GKEL's argument on issue 5 is misplaced since SEPCO's claim was allowed on an alternative claim, that is breach of implied term. I'll pause here for a moment. So the tribunal holds against SEPCO, my lord, on the issue of notice, but says this is an issue where there was an implied term to the contract. Which were those implied terms, my lord? Please see what the tribunal holds. 80 held that SEPCO did not provide notice for its claim of GKEL's breach of its obligation with respect to customs clearance. 80 then held that GKEL was in breach of an implied term of the contract. 80 assessed the evidence and legal precedent and held that GKEL was in breach of the implied obligations, that GKEL would not hinder or prevent SEPCO from performing its obligations, and 2, GKEL would cooperate with SEPCO. Now, my lord, there are a number of paragraphs. Let's take note. I cannot read all of them to save time, but please just kindly note, my lord, 376 to 380. But we have only referred to a few there. But in addition to that, let's just kindly note on, make a note on para 41, the further paragraphs, 376 to 380, 381, 383. But I am requesting the court, just spanning Rahim, I am requesting the court to note these extra additional paragraphs, which are not mentioned in para 41. I would have read them in the ordinary course, but to save time, I'm not able to read them.
Can you repeat?
376 to 380.
Yes.
381, my lord. 383. 384. 385. 251. 252. 281. 284, 286. May I just take a minute to make my submissions on this issue and move on. But please note 2 or 3 aspects that are important as far as this claim is concerned. This was a claim made in respect of a period prior to 2012. This was a claim made for the period prior to 2012. And therefore, we were in a notice situation. On not issuing notice, the tribunal holds against SEPCO. Say, SEPCO, you should have given a notice. But on facts, finds that GKEL had hindered SEPCO. Factually, had hindered SEPCO from performing, and as a result of which, Lord, customs clearance came to be delayed. And says every contract has an implied term that the contracting parties would cooperate with each other for performance of the contract and will not hinder each other's performance, and comes to a conclusion that GKEL had hindered SEPCO's performance. It's a factual inquiry on which parties had led evidence. The tribunal appreciates evidence and concludes factually that GKEL had not cooperated, rather hindered, not the performance of SEPCO's obligation. It is on that basis that the claim comes to be allowed, not on the basis, Lord, that even though notice has not been issued, the claim must be granted. Now, a party, Lord, when it sets up its case, it runs its case before the court or a tribunal, may do so on several grounds. I can have first ground, I can have an alternate ground. Your Lordship may find favor in the alternate ground, may not be the first ground. I fail in the first ground, that despite no notice I was required, but says second ground, yes, you have merit in what you say. All of this, Lord, and once again, within the realm of facts. Now, please note a few harsh facts. Harsh facts. Number 1, GKEL's counterclaim, and that's not in my note block. GKEL's counterclaim has been granted to the extent of 490 crores. 490 crores. Lordships have not been told about this. While not, Lordships are told, well, uneven approach. The tribunal was biased. 490 crores of counterclaims granted. That is not challenged. Second harsh fact. The award that your Lordships have before you, my Lord, was an award on merits. The tribunal thereafter continued, my Lord, to be in office and rendered another award on interest and costs. Between this award and the next, which is not challenged, between this award and the next award, no application made before the tribunal under sections 12 or 13 that we have no faith in you, you are biased, you are uneven-handed, you are against us. Now, the law requires a party to take steps if any of the circumstances which are legally recognized, and bias is not with utmost respect, an argument that can be raised as an afterthought. It is being raised here as an afterthought, my Lord. With utmost respect, I submit that because the merits are against us on some aspects, therefore the tribunal is biased. If your Lordships allow that kind of a test to be applied, then every judgment, I ask myself, my Lord, every judgment would be susceptible to that not challenge. That because it is against us, the court was biased. That's with utmost respect, not the test. Can't ever be the test. My Lord, judicial integrity can't be challenged so lightly. That because the judge held against me, judge was biased. With utmost respect, my Lord, That's not the legal test, can never be the legal test. The legal tests of bias are contained in schedules 4, 5, 6. Sorry, 5, 6, 7, 8. Sorry, 5 and 7. Correct. 5 and 7 to the Act. Not one pointed out during arguments before Your Lordship's Lord, and not one pointed out to the tribunal. Now, my lord, may I move on to the next argument? But next argument was made with respect, my lord, to Unit 4. Factually, that Unit 4, there was no evidence at all. There were two prongs on which I had made my case. One was cost basis, that is the cost that I have incurred as SEPCO. Another on value basis, that GKEL would have paid me had it received, my lord, Unit 4. I made my claims on these two heads, and it was argued before the tribunal, before Your Lordship's Lord, that there was no evidence before the tribunal. Now, my lord, may I just show, because I have skipped a few points, just to conclude factual aspect, because I have some law to show.
Yes.
May I just bring you back immediately to, my lord, the award, and if I may, my lord, invite your attention, my lord, to 1735, page 1735. Sorry, volume 3. Volume 3, my lord. 1735, volume 3. That would from here. Malas have page 1735.
Yes.
I am so deeply obliged. Kindly come to para 919, my lord. There is no dispute. Malas have, there is no dispute that the claimant is entitled to be paid for the cost of Unit 4 equipment that was delivered or installed. But the first sentence,
Page 1735. Yes.
The first sentence of para 919, no dispute that whatever has been supplied or installed has to be paid for. The respondent accepts that the claimant is entitled to the cost of all works completed prior to the date of suspension of the Unit 4 works, which it is accepted is August 2011. And reasonable and unavoidable cancellation charges imposed by subcontractors as a result of the termination of their subcontracts. So, my lord, liability accepted. The question was, what would be the amount? Liability is not disputed at all. Please now have 928. Para 928 at page 1737. The respondent accepts that any costs incurred by the claimant are recoverable, but submits that the other claim put forward was a false claim and asks the tribunal to dismiss the claim in its entirety. Not to shorten the references, if I may just give it a preface to what lordships are looking at in the award. I set up my cases on two prongs, as lordships have noted already. With respect to the value, my pleading is there that whatever GKEL was to pay me, I want that, or I want amounts under the settlement agreement. This is not a question with respect to those settlement agreements that were read to lordships at great length and with great alacrity, my lord. But what was not told to your lordships, my lord, is that the tribunal rejects the settlement agreement. It has not gone by the settlement agreements. The lordships were referred to, my lord, the text of the settlement agreement and shown that well, virtually minus, leaving aside not a few figures here and there, the settlement agreements are verbatim. But that's not what the tribunal has gone by. Tribunal has rejected those settlement agreements. I could have understood, my lord, that tribunal had accepted them as gospel truth. Even then, the question would, of course, be, my lord, as to whether it is a case of no evidence, or is it a case of little evidence, or is it a case where the tribunal, where the court in 34 can go into it. That would still be at large. That will still be an issue. I'm not admitting that it will be, my lord, looked at by the court. But, my lord, now can we see further? 933, 934, paragraphs 933, 934, page 1739. The tribunal rejects the suggestion, 1739. The tribunal rejects the suggestion that a false claim was constructed or put forward. The assessment was undertaken diligently and in an open and transparent manner. The multitude of variations in and the inconclusiveness of the settlement agreements, however, is such that do not establish a basis on which to assess the claim of the costs incurred by the claimant, including any storage charges and any salvage value in the equipment. So, not they disregard the settlement agreements. Now, please go further, 934. The claimant did prepare an itemized status list of the undelivered equipment. So, not as far as the delivered is concerned, 919 first sentence, and the second sentence are clear. In respect of undelivered, please now look at 934. The claimant did prepare an itemized status list of the undelivered equipment as at 24th October 2011. The next sentence is very, very important. There is no suggestion that this critical document was not accurate. Not shown to the court, my lord. It's an inconvenient fact for the appellant. This evidence and the evidence from some of the suppliers when approaches made to those suppliers at the time of hearing does establish that the claimant nonetheless has a liability to third-party suppliers for undelivered equipment in respect of which it is entitled to compensation. Then the tribunal goes into, my lord, as to what should be the quantum of compensation. That is brought in 935, 936, 937. Now, my lord, what is the state of law with respect to, my lord, quantification? But in respect of quantification, now please kindly come straight away to our compilation of judgments, my lord. In, my lord, that is the first compilation. Sorry, there's only one compilation. Kindly come to Gemini. Gemini's number? Is 2. But the second judgment in our compilation of judgments, this one is page 71, my lord.
Para?
My lord, there are several paragraphs. If you lordships want, I can narrate them just now. 25, 42, 58 and 59, 60, 61, 65, 74, 76, 78. Some of these, my lord, I had already cited and given to my lord's, my lord. But kindly come straight away to paragraph 76, my lord. To save time, let me just take you to that paragraph, my lord. Paragraph 76 at page 127, my lord. Page 127. Lord, may I read to your lordships? Not your lordships had that. Deeply obliged. The final argument that the damages that have been awarded on no basis whatsoever would again not fall within any of the exceptions contained in section 48. I'll pause here for a moment. Lord, 48 is with respect to the foreign award, and 34 is with respect to Lord, domestic and international commercial award seated in India. And with Lord, 2015 amendment, the test of both are just the same. In order to attract 48.2, read with explanation 1.3, this court in Sangyong has held that it is only in exceptional cases which involve some basic infraction of justice which shocks the conscience of the court that such a plea can be entertained. This court held the expression most basic notions of justice finds mentioned in explanation 1 to subclause 3 of section 34.2b. Here again, what is referred to is substantially or procedurally some fundamental principle of justice which has been breached and which shocks the conscience of the court. However, when it comes to the public policy of India argument based upon most basic notions of justice, it is clear that this ground can be attracted only in very exceptional circumstances when the conscience of the court is shocked by infraction of fundamental notions or principles of justice. Now, right here, Lordship's many Lordship's notes, Lord, can you take note of paragraph 36 of associate? 33 and 36. 36 particularly. Their lordships also in the Supreme Court, not while delivering associate builders, gave us a very telling example of what must shock the conscience of the court. There is an example given in para 36 of associate. The example is this. A claimant makes a claim for 30 lakhs. The tribunal awards him 45 lakhs. A claim not made, a prayer not made, a case not put up, but tribunal awards him beyond what he had even prayed for. That shocks the conscience of the court. So what that is the example. And with utmost respect, that's the kind of situation that would arise when it comes to the test of shocking the conscience of the court. Now, my lord, is there a situation here in my case? Have I not made a claim? I have made a claim. Have they not had an opportunity to answer that claim? They have had an opportunity to answer that claim. Was it that there was no evidence at all? There was pleadings, there was evidence before the tribunal. Tribunal goes by it. Now, anyone telling you, lordships, well, this was too little an evidence. This was too insignificant an evidence. This was too unreliable an evidence. Is that party, my lord, not hoodwinking the court, if I say so, my lord, with utmost respect, by inviting the court into looking at sufficiency, reliability, and correctness of the evidence before the tribunal? Now, not PC 78, my lord. That such guesstimates. So even my lord, any quantification of damages involves within it an element of guess. Because no one has lived through that, my lord. It's only a hypothetical situation of what I must have lost or what I must have gained. It's only a hypothetical situation because nobody has lived through it. So a guess, my lord, is an inherent part of quantification, whether it is by the court or by an arbitral tribunal. There will always be some guess, my lord, no quantifications.
Only when there is an insufficiency of the evidence and gaps that court cannot contemplate how to bridge that gap. Then,
That's right.
Of course, the case. Not all situations.
But maybe, but not, if I may say so, any amount of loss, any amount of lost profits would involve some amount of guesswork, in my respectful submission. Even when the evidence is brought, if I may say so, as Rosh is put to me, there is some gap. Even there, the court can make a guess plot, and that's what Gemini says.
Para 77.
I'll read 77. For using an expression. No, I must. That's my duty. Lord, I use the expression hoodwinking. Lord, Lordships may take it, Lord, that it was an immature expression of an immature mind.
No.
What I meant to submit was that the appellant has run a case before Lordships, Lord, in 37, which is not factually and legally inaccurate. Please pardon me for using that expression.
We were discussing actually, this is right. There is element of guesstimation in many of the, even in the land acquisition case also we have that. In many compensation case
that's right. In my respect to submission, most like motor vehicle, Mullah. How would you know that the person would have earned actually so much? But let's just make a guess. The statute makes a guess. Kindly see 77 and 78. But they want me to read 77. I will read 77 and 78. Arbitrator correctly held that as nothing was forthcoming from any of the appellants, he would have to make a best judgment assessment for damages. In making that assessment, he took into account the commission that was being earned by GPT from the two clients of DMC and arrived at a figure of so much per month, and then found on a reasonable estimate that they would continue to be the clients for a period of 4 years, as a result of which the figure was so much. That such guesstimates are not stranger to the law of damages in the US and other common law tradition nations has been established very early on in the judgment of Asutosh Mukherjee, J, reported as Frederick Thomas Kingsley versus King, Secretary of State for India. In this judgment, not in my respectful submission, what an amazing language by Justice Mukherjee. What an amazing clarity of expression and of that vintage. Please see what he says. It may be conceded that though every breach of duty arising out of a contract gives rise to an action for damages without proof of actual damages, Marziti versus so-and-so, the amount of damages recoverable is, as a general rule, governed by the extent of the actual loss sustained in the consequence of the Defendant's Act. In cases admitting proof of such damage, the amount must be established with reasonable certainty, commerce in re. But this does not mean that absolute certainty is required, nor in all cases is there a necessity for direct evidence as to the amount. Damages are not uncertain for the reason that the loss sustained is incapable of proof with the certainty of mathematical demonstration, or is to some extent contingent and incapable of precise measurement. As Harlan J. observed of the Supreme Court of US in so-and-so, certainty to reasonable extent is necessary, but the meaning of that language is that the loss of damages must be so far removed from speculation or doubt as to create in the minds of intelligent and reasonable men the belief that it is most likely to follow from the breach of the contract and was a probable and direct result thereof. In view of what I have read to my lords in the award, that what I had set up was not seriously challenged. Where then I ask myself a lot is a question of the tribunal coming to a conclusion on no evidence at all. In Gemini, no evidence was led at all, and the tribunal makes a guess based on whatever it does. But can it be said that no, that tribunal could make a guess in respect of a domestic award, but this tribunal in respect of an international commercial award could not even look at the limited evidence that it had and could not make a guess? Well, that would be that first respect, would it not be an unjust argument to make?
It will be unjust argument when they will fail to prove that, fail to survive the test of the tribunal observation if it fails the test of certainty to a reasonable extent. That is why Justice Mukherjee's judgment is.
That's right.
It must pass through that test.
Lord, with utmost respect, Lord, when it comes to I'm arguing on a demurrer. I'm assuming things against myself.
We think that the guesswork and wilderness are two different poles of the situation.
That is true, bro. I'm so deeply obliged. But Lord, when it comes, Lord, to an award, what your lordships have held, Lord, is again, Lord, my argument is on a demurrer. Assume that the evidence before the tribunal was insufficient to make a guesswork. Assume. But that, with utmost respect, is an argument where lordships are called upon to
Mr. Mehta, we are entering into the domain of abstracts. I'm telling you, there is a difficulties. The court never can shun the reasonableness. That is the basic foundation of the court's idea of giving reasoning. That even when you are doing the guesswork, it's like Section 114 of the Evidence Act. Court presumes certain things, but there must be some foundational evidence on the basis of which you just project and presume.
I'm so deeply obliged, which is why, my lord, I took your lordships through some parts of the award to say there is a clear foundation for what the tribunal has done.
Yes.
And that foundation is reflected in, my lord, paragraphs that I have given, my lord, 919, 928, 933 to 937. The tribunal has dealt with this, has given its reasons, and not come to a conclusion. It is not that it is out of thin air. It has simply not closed its eyes and says, Mr. Claimant, you are right. I'm allowing your claim. That's not what the tribunal has done with utmost respect.
Right.
Now, my lord, another argument of fact that was made, which is, my lord, that I, SEPCO, could not have terminated the contract, invoking principles of common law.
Yes.
The contract could only be terminated within the confines of the clause which allows for termination. Not the clause doesn't limit the circumstances of termination. One. So what I must answer is on the face of it. That clause doesn't limit. Independently of that, the law of Malad is that a party who has suffered a repudiatory breach can always take a position that I am relieved of the contract because you have repudiated the contract. You don't want to perform your contract. I am treating as a repudiatory breach. I am now relieved of my obligations under the contract. That's the law. Now, please see, my lord, paragraph 960 at 1737. 1747, I'm sorry. 1747.
Paragraph you are referring?
My lord, paragraph 960, my lord.
Volume 5.
1747. PDF would be
17
within PDF page number 317 of volume 3.
Yes. Yes, this page.
Now, my lord, please see the issue to which the tribunal, my lord, addresses itself. Issue number 13. Were the amended EPC agreements terminated by A, SEPCO accepting alleged repudiatory breaches of the amended EPC agreements by GKEL either in January 2015 or in its letter dated 31st March 2016, or B, GKEL in its letter dated 1st November 2017 following the service of a notice of default on 29 September 2017. So now two situations as to whether there was a repudiatory breach. If so, what was its effect? Now, not please see how the tribunal examines. So parties are at issue on that. They take positions. I say that you repudiated the contract and therefore I was relieved. This raises a preliminary issue. Were the claimant's common law rights excluded by the terms of the agreement? 961. Although the agreements contain a termination mechanism, the mechanism is not a comprehensive or exclusive regime. In the present case, where the contractor terminates because the owner repudiates the agreement does not provide a termination mechanism, even though the parties did, in contrast, provide a termination mechanism to the owner if civil contractor repudiates or abandons this agreement. I'll pause here for a moment. Owner, my lord, is GKEL. So if I breach or repudiate, they had a right to terminate. The question is, do I not have a right to terminate if they repudiate? Do I not also have a right, a parallel right, to treat the agreement as terminated, not because I have terminated it, but because you have repudiated and therefore I am relieved of the agreement? Repudiation lordship knows a lot. Once the party repudiates, the other party has an election, either brought to go on performing and seek its remedies, or to say, well, I am relieved, I am going to claim damages. Please can you go further? 962. The agreements do not expressly or clearly provide that the contractual termination mechanism is the exclusive remedy of the parties, nor that common law remedies would be excluded. But I'm on paragraph 962 block. First sentence.
Paragraph
962.
Yes.
The agreements do not expressly or clearly provide that the contractual termination mechanism is the exclusive remedy of the parties, nor that common law remedies would be excluded. Construction of the agreement, interpretation of the agreement by the tribunal. On what basis? Now, please see not further. As noted in the case of Gilbert versus so-and-so, one starts with the presumption that neither party intends to abandon any remedies for its breach arising by operation of law, and clear express words must be used in order to rebut this presumption. Furthermore, so not on law, they give one reasoning. Second, reasoning on facts. 963. Section 16.3.1 of the amended CWE-ETC agreement expressly provides that the claimant's contractual right to terminate for default is without prejudice to any other right or remedy the civil contractor may have under the agreement or applicable law or in equity. Consequently, the tribunal finds that the claimant's common law remedies were not excluded. So, what the clause itself says that my right to terminate is independent of, unhindered by my other remedies that I may have in the agreement or in law or in equity. Where then I ask myself, my lord, as a question for the appellant to raise before this court in 37 or 34 to say, well, how could they terminate under the principles of common law? My lord, the tribunal has at great length addressed itself to breaches committed by GKEL and found and held, and that has not been argued before your lordship's my lord at all, nor even questioned in the award, that GKEL had repudiated the contract by its breaches, an aspect not questioned before your lordship's my lord in any way, even remotely. The tribunal concludes on that and says, because GKEL had repudiated, SEPCO is relieved of the contract as a common law principle. So what I ask myself, construction of a contract, assume for a moment against me on a demurrer. The tribunal is wrong. Not a misinterpretation of a contract in terms of para 69 of Sangyong is not a ground under section 34. So even at the very highest, assuming everything against me, the tribunal, well, this is not a correct manner to read the agreement, but even that must pass muster. But the last factual argument that was made before Rosh's Not was in relation to prolongation costs. But I hope I'm not rushing too fast with facts. If there is anything that Rosh's want to ask, please feel free. It's my eagerness to not cover as much as I can.
It's all right.
Not run a marathon as it were, not within a limited short time. But if there is any question that Lordship feel you have in mind, not please feel free. It's my duty to answer them. Now came the question of an argument made on prolongation costs. An argument was made that on prolongation costs, the tribunal has believed Mr. Prudhoe, the expert of SEPCO, who said not he, but his colleagues had examined the record, which was in Mandarin. Lordship remembers this argument Lord made. Accounts were in Mandarin, in Chinese. So Mr. Prudhoe's Mandarin knowing assistants had seen that record. Mr. Prudhoe relies upon their inputs to give evidence in the arbitration on the aspect of prolongation costs. An argument is made before you that that finding is challengeable within the domain of 34. In my respect, commission not, but within the domain of 34 as a finding without evidence. Without prejudice to not my argument that this is outside of 34. Why? Because patent illegality, of which sufficiency or insufficiency or absence of evidence or perversity in examination or appreciation of evidence are a part, is not a ground for not international commercial arbitration. However, because an argument has been raised, I must answer it. Now, not kindly see even this argument, how with utmost respect, factually, how broad it is misplaced in the hands of the appellant. Please kindly come to paragraph 803, which my lords would find at page 1707. 1707. Okay. Yeah. 1707. Volume 3, my lord. Please, may please. Losses have 1707. Lordships have the page number 1707.
Yes.
Deep replies. Please see 802. In view of the tribunal's rulings on the RRTs, the UCT, PGTs, and the repudiatory breaches by the respondent, and the fact that there is now, please mark, these are very, very clear expressions not in question before you, not questioned by them even within this shocking of the conscience argument. Please see what the tribunal notes. There is no disagreement raised by the delay experts in relation to the length of the delay as assessed and claimed. So prolongation, delay, leave the costs aside. The length of delay not challenged before the tribunal. The delay that I was claiming, the length of the delay was not challenged by their expert. First aspect. Now please see further, 803. The tribunal accepts the respondent's submission that conceptually, once the claimant has established critical delay in a given period, it is entitled to the additional costs associated with being on site during this period. Whose argument not was it? Respondent's argument. Tribunal has accepted their argument. Now kindly go further. November 12, Jinan agreement did not consider or determine or have any effect on any financial claim or any claim for prolongation costs as outlined in relation to issue 2. The claimant has also established an entitlement to prolongation costs in respect of a delay of 173 days caused by the puja ceremony and the villager disturbances. I can skip 805, my lord. Kindly come to 806. Now, my lord, one is whether who's responsible for delay. Accepted. It is the respondent who is responsible for delay. Extent of delay not in question. Assessment of what should be the cost. Respondent submits that the claimant has failed to establish that its prolongation costs are, in those circumstances, the respondent submits to the tribunal should not speculate as to the costs, but must simply dismiss the claim. However, Mr. Ellison and Mr. Jain, who were witnesses of GKEL, agree with the overall approach followed by Mr. Prudhoe in assessing prolongation. Their disagreement rests on access to all of the documents. Please mark this, Lord. Please mark the word all. Your Lordships, if the matter has been argued as if whatever Mr. Prudhoe looked at was never on record, was never shown to anybody. That's how I understood the appellant's argument. That whatever Mr. Prudhoe looked at and made a calculation on was kept outside the view of GKEL.
You read the line again, please.
Yes, Lord. However, Mr. Ellison and Mr. Jain agree with the overall approach followed by Mr. Prudhoe in assessing prolongation. Their disagreement rests on access to all of the documents used by Mr. Prudhoe. They have also identified double counting in relation to the traveling costs.
So
salary.
It talks about the disagreement to access to all of the documents.
That's correct. But I'm sorry, the point that I was trying to canvass, and I will come to this point also, was this. An argument is made before you that Mr. Prudhoe looks at something. He doesn't tell us what, and he gives a figure, 100 rupees. And the tribunal says 100 rupees is allowed. That was not even the case set up before the tribunal. It's a wrong case set up before your Lordship's Lord. Their own witnesses say, I have not seen all that Mr. Prudhoe has looked at, but their case was not that the accounts in Mandarin were not available to them for them to look at, for them to translate and look at. I will show you, Lordship's Lord. I will show that, Lord. Their own admission in cross-examination, I have that, Lord. I'm going to show that, Lord. Now, Lord, please see further. Kindly come to 808, Lord. Mr. Prudhoe explained that the audited financial statements cover many projects and the total costs are confidential. He said it was not practical to reconcile the costs in the project cost ledgers which were provided with the audited financial statements. Mr. Prudhoe was satisfied from the audit that the ledgers as adjusted contain the costs incurred in the project. Claimant maintains two separate costs account for the project, one in respect of amended, second in respect of so-and-so. Mr. Prudhoe produced, now please mark this. Mr. Prudhoe produced extracts from the claimant's project cost ledgers of categories of costs which he attached to his first report. Mr. Prudhoe has assumed some delays are the responsibility of the claimant and has excluded those costs. He has prepared daily rate to apply in the windows of time on the basis that the delays may not be agreed. Mr. Prudo's Mandarin fluent assistants audited the claimant's ledgers and are satisfied that the records contain the costs for the project. Now, please mark this, my lord, the sentence that follows. It's important. Mr. Ellison did not undertake any such audit and accordingly assessed such items at nil value. Now, may I show you very quickly the cross-examination? Please see that, something that has not been placed on record in 37. Can I have a copy? So, he produces along with his first report the ledgers on which he relies, which were available to the respondents' witnesses to comment on. Okay. But they say they are assessing the claim as nil. Now, please see, this is not a transcript of cross-examination. I'm sorry for the font size, but that's how we all get it. That's how they prepare it. Kindly see 140. At the foot of the page, you would find there are 4 pages on one page. Please see page 140. That will be the second column, last page. The page would be here at the foot. Now, Mr. Prudo is being cross-examined here. I just wanted to ask you, at the top of the page, you would find that. Page 140, at the top, you would find a sentence. I just wanted to ask you. I hope you have been able to locate that. But there are 4 pages on this. I am on the 4th one. This one.
139 just below that.
That's right. 139 just below that. I just wanted to ask you. You said this in the last bit of A. It is not practical to reconcile the costs in the project ledger with the audited financial statements of SETCO because the financial statements cover many projects and I'm sorry. Justice Talapatra has been I'm sorry, my lord. I'll read it again. I just wanted to ask you, you said this in the last bit of A. It is not practical to reconcile the costs in the project ledger with the audited financial statements of SETCO because the financial statements cover many projects and the total costs are confidential. I am satisfied from our audit that the ledgers provided as adjusted contain costs incurred for the project. So is it the position, now this is the question, so is it the position that the actual costs have been kept confidential and are therefore not available? Answer is no. So in relation to the time-related cost to which this relates, prolongation cost, I obtained extracts from the project ledger, which my assistants, Chinese-speaking assistants, audited in Jinan, and they looked behind the ledgers to confirm that the costs were in fact project costs. They found some discrepancies which they adjusted for, and they also looked for costs which are time-related and excluded non-time-related costs. Then the question, you say, obtained extracts from the project ledger, which my assistants ... audited. Have you made those available to GKEL? Please see the answer. Top of page 141. Yes, they are attached to my first report. Question. In Chinese? Answer. No. There is Chinese and English. So all the extracts which you have got have been provided. Have they? The extracts that I got have been provided. Yes. Thank you. That's where the cross-examination ends on this. Yes. So to argue that, well, Mr. Prudo has blindly and in a sense of hearsay not believed what his assistants looked at, but what he never looked at. When he speaks of his assistants, all that he is saying, his assistants audited the background papers also. Not just this ledger, but the background papers, vouchers, bills, and so on. He doesn't say my assistants have prepared something and I do not, since I don't read Mandarin, I believe them. That is not with utmost respect the position of evidence before the tribunal. And this was available to the tribunal and to GKEL. And their experts don't go into it, and that's what the tribunal says. Their experts have not looked at it. Now, can GKEL argue here? Accounts were in Mandarin. And the tribunal, how has the tribunal considered it? The tribunal has considered it because you cross-examined Mr. Prudeau. Mr. Prudeau unshakenly answers that I have given it to you. You have it. You have not examined it. I can't fault you for it. That's your own fault. Now, Lord, that with utmost respect, Lord, was the argument and not its inaccuracy in the facts of this case. Now, Lord, can it be said, Lord, and I'm answering all of this, Lord, assuming, Lord, keeping aside the position of law, but assuming that not the appellant can, Lord, raise these issues under, Lord, the umbrella of shocking the conscience of the court. With utmost respect, not. Appellant may disagree. Appellant may be dissatisfied. Appellant may even not be able to persuade this honorable court to say, well, this part of the evidence is not good enough, is not sufficient. But with utmost respect, not that is precisely what not the law tells you, not is outside the scope of 34. And I don't say it, not the judgment say it. Now, not please see how the impugned judgment looks at it. Not been read to losses, not in an appeal, not even been referred to. It's been ridiculed, my lord, by saying, well, I have just argued 2 points and it has not decided one of them, only 1 point decided. With utmost respect, my lord, with great authority, the learned judge has dealt with every aspect that was urged and argued before the tribunal, before the court. And Lord, of course, not an aspect not argued before you, but not at great length they go on in the memo of appeal to say, well, I had 18 grounds, of which I urged only 2. But as the court, your lordships would apply your mind to an aspect that is argued before you. That's the law, Lord. Something that I don't feel good enough to argue before you.
There is a little problem, Mr. Counsel, that I just point out. They say the matter was taken up for admission purpose only.
Not with utmost respect, no.
No, you may say no, but what was their perspective that I'm telling and unfolding before you? They said the matter was listed for the admission. We picked up some grounds for only purpose of the admission, and we confined our submission on those 2 grounds. Meaning, implying that we did not know the matter is being taken up for the final disposal.
Assume that against me for a moment. You argue matter over 9 days before the single judge on admission. 9 days. The matter was argued on admission. And if the point which is not good enough for admission, a point in your estimation is not good enough for admission, let's assume against me, my lord, a point that is not good enough for admission is good enough for 34. I put my best foot forward when I come to 34, my lord, saying that this is it. Please admit the matter on that. I can't say my second best point that I never felt confident about was good enough to succeed in 34. Is it not an argument with that most respect, which turns on its own head? Now, please see, my lord, the impugned judgment, which has not been shown to the court. Kindly come to 530.
Okay. There is another ancillary question, whether 34 is a traditional appeal or not.
It's not.
It's not.
It's not. I'm so deeply obliged. And these are
objection.
prophetic words of this honorable court. That it is not like 30, it's not like 1996 CPC, my lord. I bow down. I began by that. And my lord, by submitting that what has been argued before your lordships, my lord, is essentially in the nature of a section 96 appeal. And I would not, I maintain that with utmost respect, that respectful submission, that as a respondent's lawyer, what I find, my lord, is a complete, not if I may say so, a wrong approach. And I say with utmost respect, my lord, my learned friends from whom I learn and I learn every day, my lord. But that is an approach of a classical, my lord, an appeal in the sense of a section 96 CPC, but not for 34. The jurisprudence is not completely different. But please see, my lord, because I'm on the impugned judgment, kindly see, my lord, what, my lord, the learned judge, my lord, deals with. 530.
530. Yes.
Page 530. For volume 1 should be PDF. PDF page number 2. Volume 1.
528 itself, I think in 3 pages there is 528, 528, 528.
I'm sorry, what?
There are 528, there are 3 pages, 528, 528, 528. This one is.
My lord, on that I can do nothing, my lord, my friend memo. But in a lighter vein, if I may say so, my lord, I'm sure, my lord. I think that must have been slipped in by mistake, my lord. One page gets.
Just I would like to just show
Make
you
it A,
this.
B, C, D, that's better.
Oh.
528A, 528B, 528C.
No, I don't have
that's
that.
better.
You just see the judgment, para 1.
The petition.
Judgment.
That's it, but it
I'll
starts
just
with the
come
petition.
to the para 1.
Yes.
What is the judge's expression?
Yes.
The matter is heard on the question of
Yes, my lord.
admission.
I'm so deeply obliged. My lord, please kindly consider. And that's why they have not run this argument. They have not made this argument before your lordship. They have not argued this. My lord, after the 2015 amendment to the Act, it's not like, my lord, a right under 96, where, my lord, a person who has made an appeal under 96 has a right to be heard in 96. If the court finds that there is no merit on the face of it for admitting the petition, it is not required to admit the petition. There is no right of an admission of a 34, unlike a right of an admission of a first appeal
Right,
under
on that
96.
point you are very clear.
I'm so
There is
deeply
no
obliged.
doubt about it.
So something, my lord, which has been urged, argued, the judge reflects on it. Written submissions made, copious written submissions made, my lord. And what a scholarship of not argument the lordships would find, my lord. Can you see, my lord? Now, para 2. Petitioner entered into an agreement. These are facts noted. I can skip that paragraph. Kindly come to 2.1. Mary, read 2.1 at page 532.
Yes.
The matter was argued at length by learned counsel for the parties on the question of admissibility of the petition. In one hand, learned counsel for the petitioner made an endeavor to encompass the argument raised within the scope of section 34. And counsel for the opposite party, on the other hand, made efforts to persuade this court, arguing that the issues raised by the learned counsel for the petitioner are not within the scope and ambit of section 34 of the Arbitration Act. 3. For convenience and appreciation of respective cases of the parties, GKEL filed convenience compilation on so-and-so, as well as additional compilation, likewise SEPCO filed, and it goes on. Mr. Salvi, learned senior advocate, as well as Dr. Singhvi, learned senior advocate vehemently argued that the tribunal has treated the parties unequally and tried to make out a third case, which was not even the case of either of the parties. It is also argued on behalf of the petitioner that by virtue of the impugn award, the tribunal has effectively modified the contract between the parties by holding that the parties have waived the requirement to issue contractual notices. Dr. Singhvi, learned senior advocate, also made elaborate submissions in response to the submissions made by Mr. Mehta, learned counsel for SEPCO. But over days the matter is heard, and not kindly see, my lord, the scholarship of the counsel, my lord, who had argued the matter. They argued at length, and all that has been argued before you was urged, my lord, in para 3 by them. Unequal treatment, new contract, no notice was required. How has the tribunal dealt with it? And so on. Arguments, my lord, of GKEL begin from para 4. I will skip that. In great detail, they take the court. This is not, it may be not for the purpose of, it's not like a typical admission hearing. A typical admission hearing where the court says for admission, is there a point or not? Please see the details to which not they take the court. Beginning from para 4. Four to 8 are the submissions made by GKEL. They refer to all and or most of what they have taken a losses through. My submissions are noted from para 9.
19?
9. Page 536. I am not taking losses through that to save time. Please now see the analysis in para 16. Page 541. Well, the principle that losses have laid down is that in 37, all that the court is required to look at is whether 34 has been rightly applied or not applied. That's why they say 37 is narrower than 34. Now, please see 16. In order to scrutinize the rival submissions raised by learned counsel for the party, the relevant provisions of the Arbitration Act as well as the case laws on the legal issues raised are to be kept in mind. Section 34 of the Arbitration Act deals with an application for setting aside an arbitral award. It provides the challenge of an arbitral award may be made only by an application for setting aside such an award in accordance with subsection 2 3 of the section. Said provisions deal with in detail the grounds on which an arbitral award can be set aside. 2A provides an arbitral award arising out of arbitrations other than international commercial arbitration may also be set aside if the court finds the award is vitiated by patent illegality appearing on the face of the award. Proviso to subsection 2A makes it clear that an award shall not be set aside merely on the ground of an erroneous application of the law or by reappreciation of evidence. Thus, it is made clear in subsection 2A the ground of patent illegality appearing on the face of the award shall not be a ground to challenge an international commercial arbitration award. Further, subsection 2A also makes it clear that an arbitral award shall not be set aside on the ground of erroneous application of the law or by reappreciation of evidence. Thus, the submission of land counsel for the parties are to be scrutinized on the narrow compass applicable to this case, keeping in mind the restrictions as aforesaid. But in my lifetime, I cannot summarize the arbitration law so beautifully and so lucidly as this learned judge has done in para 16. And I don't mean to say because not this judgment is in my favor.
So
it notes every single relevant detail and it puts it plot. Now, can you see more next paragraph? The main grounds on which the petitioner assails the arbitral award are that the tribunal has made a case out for SEPCO which was not even pleaded or argued by it. Secondly, the tribunal has modified the contract between the parties by holding that the parties had waived the requirement to issue contractual notices. Thirdly, the tribunal held that the parties had waived the requirement to issue contractual notices. It would have applied such waiver equally. It should have applied waiver equally to both the parties and GKL and not unilaterally to favor SEPCO. Learned senior advocates also made detailed argument with reference to relevant paragraphs of the impugn award. Opposite party obviously refuted not and goes on. Then Dr. Singhvi's argument are again set out from paragraph 18. Dr. Singhvi, learned senior advocate in course of argument contended that the impugn award violates 18 and 34. Well, exactly the argument made before you. The unequal treatment and so on. All of this was urged. All of this was argued over days. So it's not like a typical admission hearing where somebody is really, if I may say, taken by surprise that I came here for something else and not the hearing will turn out to be something else. And 2 hours on every day. Arbitration, as it is in conflict with the most basic notions of morality and justice, being the result of unequal treatment of the parties, while SEPCO's claims have been allowed, even though it had admittedly failed to issue any notice, GKL was treated unequally by rejecting its claim in the counterclaim amounting to more than rupees 15 crores approximately, at the threshold holding that GKL had failed to serve notice, even though all such claims arose after March 12. In support of his case, he relied upon the case law in the case of Sangyong, and para 34 and 35. Over the page, Associate Builders, 19. They do make out not a very ingenious argument on paragraph 19, out of what is quite clearly at the very highest a typographical error. But please see 19 with me. In the instant case, the arbitral tribunal, relying upon the email of Mr. Rao, came to hold that through such email Mr. Rao was asking SEPCO not to issue formal notices in any manner in future. Thus, it cannot be denied. Now, this sentence is milked, if I may say, so completely out of context by the appellant. Thus, it cannot be denied that finding with regard to waiver of notice is perverse and based on no evidence. This is the argument made before. And they say this is the conclusion of the learned single judge. It's their ground in the appeal that having so concluded, the judgment is wrong. Now, please see what follows. As held in associate, an award based on little evidence or no evidence, which does not measure up in quality to a trained legal mind, would not be held to be invalid on this score. This court on reappreciation of evidence cannot comment upon the quantity and quality of evidence relied upon by the tribunal to come to a definite finding unless it shocks the conscience of the court. On perusal of relevant paragraphs of the impugn award referred to by learned counsel for the parties, it is manifest that the tribunal has dealt with the rival contentions of the parties while recording finding of waiver of notices. It would not be out of place to mention here that the claim of SEPCO with regard to waiver of notices in certain aspects have also been rejected by the tribunal, holding that waiver of notices in such matters is not permissible in law. I'll pause here for a moment, Lord. All that lordships have seen of the award that my friends have shown and what I have tried to show, is this not, Lord, in conformity? Is the observation in para 19 not in conformity with what lordships have seen of the award? I ask myself. The tribunal has applied its mind, has gone into and has come to a conclusion. Now, please see that the learned judge doesn't stop there. Allegation of bias is a serious allegation against the tribunal, and the same has to be viewed with circumspection. Arbitration Act is a complete code, and it provides mechanism to raise such issues before the tribunal itself. Then it sets out 12 and 13. But to save time, may I skip this plot? To save time, may I skip reading the remaining part? Because I just have half an hour. I have some more aspects to canvas before I end by 4. It is the allegation of the petition the tribunal adopted a double standard to appreciate respective cases of the parties, when in one hand the tribunal waived the requirement of issuance of notices by the opposite party, basing upon the email issued by Mr. Rao, on the other hand, rejected the claim of the petition. The tribunal in para 191 of the award has observed the petitioner GKL raised its issue that the claimant SEPCO's failure to give notices in the statement of defense and counterclaim and submitted that if the tribunal is satisfied that requirement of a notice is the condition precedent, the claim and the majority of claims of the claimant fall away. Taking into consideration the issue raised by GKL, the tribunal proceeded to decide in a contractual notice a condition precedent, while adjudicating the tribunal also considered relevant clauses of amended agreement. In order to consider the plea raised by the petitioner, it is relevant to quote the discussion at paragraphs 199 to 200. Now, then those are quoted. May I skip that now? In furtherance of the aforesaid observations, the tribunal proceeded to discuss various different provisions of CWE-ETC agreement, wherein reference to the notice was made, taking into consideration the relevant provisions of CEWE-ETC agreement, arguments of the parties, and referring the material on record. The tribunal rendered the findings with regard to requirement of notice pursuant to the meeting in March 2010. The finding reads as under. Now, 226 is then set out. The tribunal then proceeded to discuss about the waiver of notice taking into consideration the meeting in March 12 between the representatives of the parties. In the course of discussion, the observation of the tribunal at para 234 is relevant, then 234 is set out. In support of its case, the petitioner relied upon the English law in the case of Rock Advertising versus so-and-so. The relevant portion of the case law reads as under. Discussing the rival contention over the page, discussing the rival contention of the parties in light of the ratio supra, the tribunal came to the following finding. Then the judge sets out the finding of the tribunal. 21.2. In view of the above, it can be safely concluded that the petitioner itself raised the issue of waiver estoppel, relying upon the materials available on record, also the English law in support of its case. Thus, by no stretch of imagination, it can be said that the petitioner did not get an opportunity to produce materials in support of its case with regard to waiver estoppel. I'll pause here for a moment. With utmost respect, not I submit. What losses would look at, Lord, when it comes to Lord, the principle of shocking of the conscience of the court, is whether or not you have had an opportunity to know what is the case of the other party, to look at the documents. Whether, Lord, both the parties have had an opportunity of making pleadings in response to the other party's case, have had an opportunity to adduce evidence in support of their case, and in refute, in answering the case of the other side, and has the tribunal considered. That's all. The learned judge says this was an issue, and quite rightly, with utmost respect, this was an issue. Parties were at issue. Parties led evidence on that issue. The tribunal has made a conclusion on that issue. Now, I'm not kindly see further. It is a case that the petitioner itself raised the issue of waiver estoppel and fell prey to it. As discussed earlier, the ratio in associate builders restricts the power of this court to interfere with the findings of the tribunal, which is based on little evidence or no evidence, which it has not measured up in quality of trained legal mind. In view of the above, the plea of Dr. Singhvi, learned senior advocate, to the effect that the tribunal has made out a third case which was not even pleaded and argued, is not sustainable. Also, the plea of Mr. Salve, learned counsel, and Dr. Singhvi, learned senior advocate, that the tribunal has modified the contract between the parties by holding the parties have waived the requirement of issue of contractual notice, is not sustainable. But I ask myself, but within 37, when Lordships are looking at whether or not the court below has looked at, applied its mind to the parameters under 34, the court has. It has come to a conclusion. Lordships are sitting in a narrower jurisdiction of 37. In a narrower jurisdiction of 37. And I don't say it, not as I said, it's a judgment that Lordships have laid down, which say it. Now, please go further, note 22. It is also argued on behalf of the petitioner that the tribunal, having held the parties have waived the requirement of issuance of contractual notice, it should have applied such waiver equally to both SEPCO and GKL, and not unilaterally in favor of SEPCO. It is further argued that the tribunal has effectively adopted different standards for each of the parties and treated them unequally. And that's the argument block. 22.1. Now the judge not deals with that argument. It is also well settled that an award is liable to be set aside if the principles of natural justice have been breached or Section 18 of the Arbitration Act has been violated. In view of the discussions made above, it can neither be said that the principles of natural justice have been violated, nor the parties to the arbitration have been treated unequally. It is argued on behalf of the petitioner that the tribunal, taking note of the aforesaid notices dated so-and-so, 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 which were issued by SEPCO to GKL. Now, these are subsequent notices. Lordships remembers the argument of post-2012 notices. which were issued by SEPCO to GKL, held that these notices were akin to the notices of 7th March issued by GKL. It is further contended that the tribunal did not give any weightage to the notice dated 7th March and heavily relying upon the subsequent email as well as the notice as aforesaid by SEPCO allowed their claim. Learned counsel refuted such plea, stating that the such notices cannot be compared with the email issued by the representative of the petitioner to answer the issue of estoppel waiver of contractual notices issued. It is his contention that so and so, but then my submissions are recorded. 23.1. Now the court not applies its mind. Issue of waiver estoppel of contractual notices as discussed above, but neither relating to extension of time, delay, which were either, not neither, either relating to extension of time, delay, and damages, etc. But the notices dated so and so, so and so, so and so are with regard to the notices for breach of warrant. Thus, so and so has rightly pointed out that the plea of waiver estoppel will not be applicable to the said notices, as it would not be possible on the part of SEPCO to know the defects unless the same is intimated by the petitioner to SEPCO. Thus, it cannot be said that the tribunal has rewritten the contract between the parties. Dr. Singhvi and his senior advocate, in order to invoke the jurisdiction of this court under 34, reiterated his argument and contended that when the tribunal has not modified the contract between the parties and created a new contract by holding that the parties had waived the requirement to comply the notice provision based on verbal communication, and a simple letter in contravention to specific provisions of the agreement certainly violates the provision under Section 18 of the Arbitration Act as in breach of fundamental principles of justice. In support of his case, he relied upon Sangyong. Over the page 24.1, the court applied its mind. As discussed earlier in the instant case, the tribunal has not rewritten the contract. When an issue with regard to waiver estoppel of issuance of notices in violation of the amended agreement was raised by the petitioner, the tribunal was obliged to answer the same on the basis of the materials available on record. Accordingly, on discussion of the materials on record, the tribunal came to a conclusion that the parties have agreed to waive issuance of notices as per the contractual provision. The tribunal, while answering the issue, has rejected the plea of waiver of contractual notices by SEPCO, relying upon the events of March 2010 only. Basing upon the materials on record, the tribunal came to a conclusion that by their conduct in March 2012, the parties have consciously and diligently decided to waive issuance of contractual notices, although the material available may not be sufficient to come to the impugned conclusion as alleged by the petition. But that cannot be a ground for interference in view of the case law discussed earlier. Further, the finding of the tribunal does not shock the conscience of the court, which would warrant interference with the impugned award under Section 34 on the plea of breach of fundamental principles of justice. Thus, it cannot be said that the finding is contrary to the public policy of India in then the conclusion in the paragraphs that follow at 553. Now, I ask myself this question. Having found against the petitioner on the aspects that were argued in great length and detail with great scholarship, and I could not have matched that scholarship at all, the court comes to a conclusion that I don't have a ground for admission. Now, please assume for a moment, was it open and available for the learned single judge to say, I haven't found in favor of the petition on the grounds that were argued at great length before me. But there are many which have not been argued before. So therefore, I will admit the petition. But I will be before Lordship saying that, but how is it? Where is the question of admission of a petition? When the aspects that are argued at great length have not found favor with the court. But we all set up a case. In our arguments, we choose our arguments, what are we need to make. And what is it that Lordships have heard, which the single judge did not hear?
Do you kindly come to the paragraph 24.1 of the judgment?
24.1, yes.
Almost in the middle part, it starts with basing upon the materials and records.
Yes, Lord.
The tribunal came to a conclusion that by their conduct in March 2012,
yes, Lord,
the parties have consciously and diligently decided to waive issuance of contractual notices.
Yes.
Do you support this statement? That what you have argued so far?
Yes, Lord.
You support this?
I'm sorry, Lord. I support what not? Basing upon the materials on record, the tribunal came to a conclusion that by their conduct in March. Yes, Lord, absolutely. That's the conclusion of the tribunal, Lord.
No, but what you have argued so far, that so far the waiver is concerned only issue number 2. The statement here is that this is issue of the general waiver.
No, Lord, I'm sorry. This is considering the argument that was placed before the court and that the court noted.
That is what I'm pointing out.
No, I'm sorry, Lord. In 24.1, it was not the argument. In 24, it was not the argument that all notices have been waived. And the Previously, not please see the single
No,
judge.
this is the analysis of the learned judge.
That's right.
In regarding the tribunal observation.
Yes, my lord. With utmost respect, my lord, the context even of 24.1 are the delay notices. The learned judge goes has also concluded in
I'm
earlier
talking about the expression.
Yes, my lord.
I'm talking about the expression that to waive the issuance of the contractual notices.
Yes, my lord.
All right.
But not losses would read the judgment in the context that it.
No,
it
obviously we
takes
should read, but I'm pointing out, I need your clarification on this
in my
expression.
respectful submission.
Yes.
The context of 24.1 are those notices which could have been waived.
Okay.
The learned judge is only dealing with that argument that was made before the learned judge. It was not the point before the learned judge that the tribunal has, in respect of every single situation, come to a conclusion of waiver, because that's not the finding of the tribunal. The argument that was made was in the context of waiver of notices. And on that, the court concludes that based on material that the tribunal had before it, the tribunal has made a conclusion that the parties have waived the requirement. It's not the conclusion of the learned judge, my lord, that in every case it was, my lord, it has been waived. And 23.1, kindly see, my lord, 23.1.
According to you, 24.1 is not the observation of the court.
It is an observation of the court.
And this is the next paragraph. He says in para 25 that in view of the matter, this court is of the considered opinion that impugned error doesn't fall under the category which warrants interference under section 34 of the Arbitration Act. This is the basis, is the 24.
Not on the basis of all that
No, just I'm telling you, this
I'm sorry,
24 is of the one of the bases that he is
That's
considered.
correct. That's correct. Not. And please kindly now see 23.1 again with me.
Yes, yes.
Kindly see 23.1. Issue of waiver estoppel of contractual notices, as discussed above, were either relating to extension of time, delay, and damages, etc. But the notices are with regard to notices of breach of warranty.
Yes.
But 24.1, the learned court, my lord, is dealing with an argument of, my lord, waiver in the manner in which the tribunal has inferred. Perhaps the expression, not in Lordship's consideration, could have been better, but that's not the point, with utmost respect.
I'm not talking of the better expression. I was talking of the expression itself.
Not with utmost respect, that expression, Lord. With utmost respect, I submit, and with great sense of responsibility.
No, you said that this is in the perspective of only the delay and the.
Not with utmost respect, the expression with utmost respect, I submit, and with great sense of responsibility. It's absolutely correct. Because the tribunal, the court is considering. That's right. Losses would read 24.1 along with 23, 23.1, 24, 24.1. What losses have taught us, my lord, is that the judgment has to be read as a whole. The losses would look at, my lord, and therefore, in my respectful submission, the learned judge is applying his mind as to whether or not the tribunal had material before it to conclude waiver. And the tribunal, on the basis of that, has come to a factual conclusion of waiver. And not, that was precisely their argument.
26 may also be seen.
I will see that. I'll
All
read
right,
that.
all right. I'm just pointing out that.
And kindly see, my lord, I have given Lordship's, my lord, the paragraphs of their argument. Not paragraphs 4 to 8 are their arguments. Please note that, not what was argued before the court. The finding in 24.1, with greatest respect and responsibility, is absolutely correct to say the tribunal had basis to come to a conclusion. It has come to a conclusion. He is not giving a finding of fact. He cannot give a finding of fact. He is only seeing as to whether the tribunal has given a finding of fact or not, and which is what he records, my lord. He is not adjudicating facts. He is not adjudicating questions of evidence. He is only seeing as to whether the tribunal has come to a conclusion or not, which is what he does, what he says in 24.1. Right. Then 25, 26, 27, 28.
26.
I'm sorry, my lord. 26, my lord. Since this, yes, my lord, 26. Since this court has already come to a conclusion that the petitioner failed to satisfy the court for interference in the impugned award under section 34 of the Arbitration Act, there is no occasion to deal with the issue with regard to suspension and cancellation of Unit 4. As it relates to, please mark this, as it relates to quantum of award and cost, had the petitioner been successful in satisfying the court with regard to admissibility of the petition, then occasion to consider the issue would have arisen. Yes. If the petitioner has not been able to satisfy the court on the issue of admission, that there is an aspect within the domain of 34 for the court to look at in respect of Unit 4, what has been argued, what has been argued.
Whether the issue relating to Unit 4 was part of the objection under the petition under section 34?
It was.
And what is the observation? That this would have been arisen, means I am not considering right at this point of time.
Yes, Lord.
Is it not so, the observation? The maintainability is one thing. What is the maintainability? That he has rejected the ground of the waiver, right? Is it a issue of the legal maintainability? No. Waiver is a mixed question of fact and law.
Lord, in that case, outside of 34.
That is what you can argue, but this is a separate ground they are raised in the objection.
But not kindly see what has been, assume everything again, assume it against me, Lord, for a moment. In respect of unit 4, what has been
No, we are to giving you this point.
I bow down.
They have
I bow
asserted
down.
against you.
Lord, I bow down. In respect of unit 4, let's not, Lordships would look at not the substance. Let's take the bull by the horns. Let's take the bull by the horns. What is the point in unit 4? I ask myself, Lord. The point in unit 4 is, according to them, there was no evidence. I have shown to the court, Lord, how the tribunal has dealt with it. And in my respectful submission, Lord, all of this, the tribunal has applied its mind. You may consider the material sufficient, you may consider it insufficient, you may consider the finding absolutely wrong. But that's not for a 34 court to look at, Lord. And if it is not for a 34 court to look at, Lord, what is it that the learned judge could have done in 34, Lord? I ask myself. Now, please see, Lord. Please see a few judgments, because that's what I mean.
Is it the reasoning that what you are now just advancing to us?
Yes, Lord.
That he would, this is not his reasoning. He says only this ground, the preliminary ground that was taken for purpose of the admission would survived, then we could have taken to that ground. That is only on the point that they have pointed out very emphatically, that our all points we did not argue and the learned judge has not considered.
But Lord, if I may say so, may I just say so, Lord? Has the appellant said Lordships would remand the matter? I have not heard the appellant to argue that. Appellant has argued is 37 as if Lordships would decide 37. Lordships have put that to me and I'm answering. In my respectful submission, insofar as unit 4 is concerned, the question with utmost respect I submit and with great sense of responsibility is completely out of the 34.
All right, you argue that.
That's right, Lord. That's
but
my
you
submission.
Support this finding also
That's
at
right,
the same
Lord.
time.
That's right, Lord. With utmost respect. The learned judge says, well, I have not been able to persuade myself to admit this petition because there is nothing urged before me which can bring it within 34. And as far as unit 4 is concerned, it's with respect to quantification. Matters of quantification are not within 34. Now, my Lord, I just have very quickly two aspects, Lord, if I may move on with Lord's permission. Two aspects. One is a handout that I am giving with respect, Lord, to what was the evidence before the tribunal on each aspect. I am not reading it. We have just compiled it. Lordships wanted us to do so, but we have done it. They've given a copy not to the other side. And it's also been e-filed. It's on a Lordships record. Then, my Lord. Huh? I'll give my copy. No, I have another one. But just make sure that last page no निकल गया है वो नहीं उसी के साथ है. Just be careful. Just be careful.
All right.
At times these pages have a habit of running away. Now, my Lord, please see, just as a one minute indulgence, what we have put, my Lord, is what was before the tribunal. This table was before the tribunal in this very form. We have just simply printed it from the arbitral record. We have not compiled it. We have simply printed it from the arbitral record before this court. Although, Lord, I say this is not the inquiry that Lordships would look at, Lord, in 34 or 37. But since a question has been put, Lord, which was a factual question has been argued, which in my respectful submission is not maintainable within 34 or 37. I'm just placing before the court as to what was the evidence, and this is not each issue wise. What was the pleading? What was the evidence affidavit? What was not the documents referred to by the parties? This is from the arbitral record. Issue wise, with respect to every issue, it goes up to 27. But I had indicated to my Lord's Lord that to save time, we will also compile the ratio of all the judgments that we relied upon, so that Lordships are not spared, and not I wish that Lordships would not look at that huge thick compilation, but only to save time, the relevant paragraphs have all been extracted. I want to make a few references to that, Lord. Just kindly have that, Lord. Don't worry about the page numbers. my lord, your lordships would find from this compilation some of the references that we have already, my lord, taken lordships through. My lord, that is Sangyong. Lord, we have taken the liberty. Your lordships would not.
We'll look into this because these are argued already.
That's right. No, but not some of them, yes. Some of them I wanted to
Which are
highlight.
not argued by you, that those you point out. Associate
I-
builders.
So that's right.
Gemini
Now-
Bay.
Now, my lord,
Exhaustively, you just.
as far as associate is concerned, may I just invite, Lord, there are a couple of aspects that I just want to highlight. I'm not reading them
Yes.
copiously. Sangyong, my lord, lordships have seen in great
Yes.
detail. But please see, my lord, just to re-emphasize, kindly see what 69 says of Sangyong. 69, my lord. Page 4 of the note. This is what just to contextualize all that lordships have heard over these days, and as to whether that is within 34 or 37 or not. In my respective submission, not. Please see what the court says. Following the aforesaid authorities, that in the guise of misinterpretation of the contract and consequent errors of jurisdiction, it is not possible to state that the arbitral award would be beyond the scope of submission to arbitration if otherwise the aforesaid misinterpretation, which would include going beyond the terms of the contract, please note this, which would include going beyond the, could be said to have been fairly comprehended as disputes within the arbitration agreement, or which were referred to the decision of the arbitrators as understood with the authorities above. I'll pause it for a moment. Entirety of the issue of waiver, estoppel, and so on was before the tribunal. It's been referred to the tribunal. Parties have argued their case before the tribunal. But this is what it says. If an arbitrator is alleged to have wandered outside the contract and dealt with matters not allotted to him, this would be a jurisdictional error, which could be corrected on the ground of patent illegality, which, as we have seen above, would not apply to international commercial arbitration. So, not even if this error has crept into the award, even that is outside not the domain of 34 when it comes to an international commercial arbitration. It's a bitter pill to swallow, but that's what it is. It's a bitter pill to swallow, my lord, to say, well, even if it travels beyond the contract, the court should not be called upon to look at it. But that's what the law is. If there's a bitter pill, my lord, it's a bitter pill for everybody. To bring it, now please see, my lord, to bring it by the backdoor grounds available, relatable to 28.3 to the matters, to be matters beyond the scope of submission to arbitration would not be permissible, as this ground must be construed narrowly, and if so construed, must refer only to matters that are beyond the arbitration agreement or beyond the reference to arbitral tribunal. And not lordship notes in the facts of Sangyong I highlighted. Even the court doesn't fault the award on the basis that the tribunal should not have considered it, and therefore it was beyond that circular. The court faults the award on the ground of public policy for the reason that it was never put to anybody. The document was never put to anybody. Is that the case in my respectful submission in the present case? With respect, no. Then there is one judgment, which is Punjab State Civil Supplies, which was not, Lord, as a part of our, I had not read it. We have extracted that, Lord. That is the second judgment. Over the page, Lord, lordships would find Vijay Karya. Then, Lord, associate builders. Lord, we have extracted the relevant, paragraphs, but kindly see a few observations which we have highlighted for your lordship's consideration. 33. It must clearly be understood that when a court, and now only a small part of associate is the continuing law, not the entirety of associate. It must clearly be understood that when a court is applying the public policy test to an arbitral award, it does not act as a court of appeal, and consequently errors of fact cannot be corrected. A possible view by the arbitrator on facts as necessarily to pass muster, as the arbitrator is the ultimate master. I'm so deeply obliged. Losses, not just Talapatra has put this to me, that there was a qualification in 33, which is precisely what I'm reading. Exactly. A possible view by the arbitrator on facts as necessary to pass muster, as the arbitrator is the ultimate master of the quality and quantity of evidence to be relied upon when he delivers his arbitral award. Thus, an award based on little evidence or no evidence, which does not measure up in quality, to a trained legal mind would not be held to be invalid on this score. Then, Lord, Gemini B, Lord, I have Lord, given a few paragraphs to your lordships, Lord. Please see, Lord, what they say, Lord, in para 60, which is not extracted. The ground, Lord, third line in para 60, page 9. The ground of patent illegality appearing on the face of the award is an independent ground of challenge which applies only to awards made under Part 1, which do not involve international commercial arbitration. In other words, my lord, a patently illegal international commercial award cannot be set aside. Thus, the public policy of India grounds under the 2015 amendment does not take within its scope perversity of an award as a ground to set aside. And if perversity is not a ground, I ask myself, my lord, which of the aspects that have been urged? Because all that has been urged only speaks to perversity, not that it establishes perversity, but it only speaks to, my lord, perversity as a ground. And perversity is not a ground. So all that losses have heard from the appellant, that most is not tenable in view of what losses seem lord in Gemini Bay. Lord, please kindly go over the page, lord. Then there is lord MMTC Vedanta, which we refer to but not read. 16 is important. Can you see lord paragraph 16? Losses put a question to me. The terms of the contract are there. And I said, lord, the losses would look at the terms in the context of how the parties behaved for the purposes of not writing of letters and so on. Please see note 16, page 11. It is equally important to observe at this juncture that while interpreting the terms of a contract, the conduct of the parties and correspondences exchange would also be relevant factors, and it is within the arbitrator's jurisdiction to consider the same. Now, this was in the context of a domestic award. Situation is not, if I may say so, not far different when it comes to an international commercial award. Something which
this is mostly relating to the supplemental formation of this contract, the correspondences is made.
No. This was subsequent. No. In interpretation of the contract which is already formed, how the parties have subsequently behaved is also a relevant factor.
That is for purpose of understanding the meaning of the contract.
That's right. So how the parties behave, lord, with most respect, would throw light as to whether the parties consider it to be an absolute must or the parties consider that we can waive it.
That's true.
Now, lord, and it is while interpreting the terms of the contract is what the Supreme Court says, lord. Then, lord, we have a classic, lord, a caution line, if I may call it, lord, in DMRC to say that, lord, that the courts cannot look at, lord, the appreciation or reappreciation of matters of fact as well as law. Para 26 of DMRC.
Yes.
And the caution is sounded, lord, in paragraphs 28, 29. Kindly see 29, lord. Patent illegality should be illegality which goes to the root of the matter. In other, although it's not a ground for international commercial award, but for a domestic law, can you see what they say? Erroneous application of law cannot be categorized as patent illegality. Contravention of not linked to public policy or public interest is beyond the scope of expression. What is prohibited? So even a patently illegal domestic award which illegally does not go to the root of the matter, will not be disturbed in 34. What is prohibited is for the courts to reappreciate evidence to conclude that the award suffers from patent illegality appearing on the face of the award as the courts don't sit in appeal against the arbitral award. Not 48, 49. Now, not kindly come to the next aspect, 37. These are not judgments rendered by Loshes Mullah. Some of this honorable court, or judgment of this court, the first judgment I read to my Lord's Lord Kali Karmakar, that was a Tripura High Court judgment. Very Loshes Mullah deal with the ambit of a section 37. And kindly see what the Loshes say, law. Appeal under section 37 of the Act is unique and unlike the appeals as generally understood in legal parlance. The scope of appeal filed under 37 is confined inter alia to setting aside or refusing to set aside an arbitral award under 34. As such, it is apparent that the scope or ambit of the appeal is restricted to assessment or appraisal whether the order passed in exercise of powers conferred by 34 was so exercised within the provinces as laid down. This is precisely not what I have been submitting for Lord's consideration. Is wrong on the part of the appellant in approaching its arguments in section 37. 8. It is apparent from the application filed under section 34 that the appellant has challenged the arbitral award for its being, according to him, in conflict with the public policy of India, and that ground is entirely based on sole arbitrator as improper appreciation of evidence. Precisely what has been argued before Lordship not over days by the appellant. Page 13. 9. Para 9 then. In Viraj Holding versus Motilal Oswal, it has been succinctly held that the challenges to an award only on factual aspects cannot be maintained, and such challenge does not come within the ambit of 34(2) of the Act. The law as enunciated by the Bombay High Court in Calcutta is harmonious. Not then Loshes go on to not cite various other judgments.
Yes.
And not please see what Lordship observe in para 10. The court cannot function as an appellate court and cannot substitute its own findings in place of evaluation of the arbitrator. Merits cannot be looked at under the broad head of public policy and so on. Then, my lord, of this honorable court in HCIL, please see not what Lordships have held, my lord. And as I said, it's not my language. It was never my effort to say, my lord, I will not answer a question of fact, but a question of fact will not be gone into in 34. That's the expression that this court has used. Please see what para 30. The law is no longer as integral, that where the arbitrator has assessed the material and evidence placed before him in detail, the court, while considering the objections under section 34 of the Act, does not sit as a court of appeal and is not expected to reappreciate the entire evidence and reassess the case of the parties. The duty of the court in these circumstances is to see whether the view taken by the arbitrator is a plausible view on the facts, pleadings, and evidence before the arbitrator. The court is not to substitute its view with the view of the arbitrator if the view taken by the arbitrator is supposed by his own reasoning. The same has been previously reiterated by this court in state of Orissa versus so and so. It is seen that the arbitrator has elaborately considered the various documents, submissions, and evidence led by the parties from a brief glance at the arbitral award. Then the sole arbitrator framed 5 issues for consideration. After going through the award dated so and so, it is clear that the arbitrator has referred to all the relevant clauses in the agreement between the parties and passed detailed findings with respect to each issue. The arbitrator has in fact passed individual findings for each of the claims items after referring to the evidence produced with respect to each claim separately. The civil judge in the impugned judgment has taken note of the same and has also been mindful of the fact that the tribunal has not baselessly awarded whatever the amounts claimed were, but has exercised its mind in arriving at an appropriate amount for each claim that was awarded. Now, Lord, then Lordship said, limited scope in 37, rejected. Appeal rejected. Likewise, Lord, in 10. And these words are prophetic, repeatedly, Lord, emphasized by Lordship's Lord. Please see 10, para 22, Lord, of United India. We may note that the law laid down by the Supreme Court constricts the supervisory role of the courts while testing the validity of an arbitral award. In the case of McDermott versus Burns Standard, now please see what it says. 96 Act makes provision for the supervisory role of the courts for the review of the arbitral award only to ensure fairness. Intervention of the court is envisaged in few circumstances only, like in case of fraud or bias by the tribunal. Not fraud, bias, corruption, but they pollute the most noblest of streams. There can be no exception to fraud or corruption in any form, be it not an award or be it not any other judicial determination. Those are, my lord, if I may say so, the extreme grounds that the Act says should be, my lord, looked at. Nothing short of that. It can only quash the award, leaving parties to begin, then it goes on. Lordships not take note of UHL in that judgment. And a variety, and a number of other judgments, my lord, MMDC, Vedanta, and so on. Likewise, another judgment of this court, my lord, in New India Assurance, number 11. Please kindly see, my lord, and how significantly it is applicable to this case. In the present case, apart from vague averment, the learned arbitrator is an officer of the state and R1 is an instrumentality of the state. The applicant has not been able to demonstrate. This was in the respect, not of bias, where not a counsel was made as an arbitrator who was not associated with the State Advocate General's office, and the argument was that he's a State Advocate General's office. So where is the question of his determining the case in an unbiased way? Lordship said bias is not something that you can simply plead and argue. You must demonstrate. And this is not with utmost respect, not you can't just look at it as an afterthought, make an argument as an afterthought. Precisely the error that the appellant makes in my case. The tribunal is biased. Why? Because the finding is against me. But what about the findings in your favor? Is finding oriented test a test of bias? No. It can never be. It is not. Then not please see that I have already cited not NHAI versus GBK. Not regarding quantification, we have cited not Mahanagar versus Babulal, judgment of the Honorable Bombay High Court. Lordships can kindly see, my lord. Arbitrator applied rough and ready formula to arrive at the damages payable. Once the arbitrator arrives at a figure, even by guesswork, the court may not interfere with it if it is not unreasonable. This is all with domestic award. I am at a higher pedestal as an international commercial award. So it can never be that what is available or what is not available for challenge as a domestic award is available readily for international commercial award. Now, my lord, lastly, an aspect that Lordships put to me, although it has not been argued by the appellant, but Lordships put to me that the learned single judge has looked at certain aspects that were urged. and not looked at the grounds that were detailed in the petition. Please see what the Supreme Court tells us, not in the Mansi. Judgment number 13. The final, page 18. The final submission was that several other questions were raised in the writ petition before the High Court, but they were not considered. We attach no significance to the submission. It is not unusual for parties and counsel to raise innumerable grounds in the petition and memorandum of appeal, but later confine themselves in the course of arguments to a few of those grounds, obviously because the rest of the grounds are considered even by them to be untenable. No party or counsel is thereafter entitled to make a grievance that the grounds not argued were not considered. Not, please don't allow the appellant to open floodgates. Tomorrow, my lord, every litigant will urge 100 grounds and no less in every petition. Argue 2 and then come to Lordship's not as an appeal court to say 98 were not considered. And Lord, that is how it goes on. Lord, there are some. I've overshot my time. I'm sorry. Lordships have a meeting. Lord, I've compiled this with Lordship's permission. Lord, we have highlighted. Please don't take it amiss, Lord, that we have highlighted. We only wanted, Lord, Lordship's time to be saved while looking at these judgments as to what, according to us, was the ratio in each of these judges. So, I most respectfully submit, therefore, that this appeal is without merit. It is completely outside of 30. It is completely, therefore, outside of 37. And not within the narrower scope of 37, this appeal, not with utmost respect, deserves to be dismissed. I am so deeply obliged and grateful. And if I have committed any mistake, my lord, that remains mine. Lordships would pardon me for it, but not my error. Submission, not our effort was only to assist the court in the best way that we could. I'm so deeply obliged.
Well, your lordship wanted the notes to be provided. Can you give some time to provide it, my lord?
You want to file notes, further notes?
Yes, my lord.
We have not asked you to file any note. If you want to file, we can provide some time, but it is also to be filed within 7th.
7 days, right?
Not 7th.
By
7th of
7th.
August.
By 7th.
And after that.
Right.
Lord, all I can say is Lordships have always been a hard taskmaster. Allow me to crack that joke. I'm so deeply obliged. But yes, Lordships have indicated time.
Final polished note.
We'll respect it. We'll respect it. By 7th of August. So deeply obliged. It was a privilege to appear before Lordships.
Hearing is complete. Judgment stands resolved. However, on request of Mr. S.P. Mishra.
But we also will tender some notes, both the parties.
Learned Senior Counsel is stated by such and such, find out from the record. We permit the appellate to file a brief of notes of submission. Notes of submission.
Note of submission.
By 7th of August 2023. If the respondents intends to file any such notes, they are allowed to file it by 11th of August.
I'm so deeply obliged.
2023.
Most grateful. Deeply obliged.
The records be record be compiled only thereafter.
So deeply obliged. Most grateful, Lord. It was a privilege not appearing. So deeply obliged for a very patient hearing.
It was indeed a privilege.
Grateful, man.
Most grateful.
Thank you, everyone.
What do you